don't stop. She don't miss nothing, got the scoop on lock. Spilling all the tea while it's still too hot. Lakeysha Keysha, queen of the plot. Hit that bell, cause the tea don't stop. She don't miss nothing, got the scoop on lock. Spilling all the tea while it's still too hot. Lakeysha Keysha.
Hey guys, we are back. I told y'all I have these videos and we are going to just play them out today. Now it's going to be a little long, but I told y'all the court started at 9:30 and we were not done to 7. I left at 7:15 and the computers and everything went out. So we're going to get started. Thank you, to everybody that's here. If you guys are not following me on Facebook, TikTok, Instagram, Snapchat, and Twitch, please go ahead and follow me. But we're going to get started, y'all.
So if you guys started dating in around May of 2021.
And, just trying to keep
Okay, and let me just stop, just so if you guys have not watched earlier videos, you're going to have to go back and watch them. We are starting with Porsha Williams' testimony. From Porsha Williams, you guys know who Porsha Williams is. Porsha Williams, Real Housewives of Atlanta. We are watching her divorce proceedings. I have a lot of videos out there where I showed y'all some of the videos because it is extremely long. Now, this is going to start off with Porsha Williams' testimony. She's going to be cross-examined by Simon's attorney. Then you guys will hear Simon. He will testify, and then we'll go into what the judge says.
Keep a little control over it. So that's actually why I'm sitting out in the courtroom right now, because I knew this case is a little bit high profile, and so if the public or anybody else wanted to show up, I'm not handing Zoom links out. They can come into my courtroom and observe it.
Thank you.
Okay, so Ms. Hayward James, I'll go ahead and swear in Ms. Williams then. Ms. Williams, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth in the testimony you are about to give?
Yes, I do.
All right, if you could state your name and spell it for the record.
Porsha Williams, PORSHAWILLIAMS.
Okay, Ms. Hayward James, it's go ahead with your direct.
All right, Ms. Williams, where do you currently live?
Okay, so I'm going to go a little bit because y'all can't know where the girl live and all of that, but let's. Okay.
2021.
So what y'all, the little bit that y'all missed, she was asked, when did she move into the marital residence? The part that I fast forward just a little because she asked her, what is the address of the marital residence? Then she asked her, when did you move into the marital residence? And that's when she said 2021.
So yeah, around that time.
And you said that his children moved into your residence during that time?
Yes.
And do you have any children?
Yeah.
What's their name and age?
I have one daughter, Pilar McKinley, and she's 6 years old.
Was she also living with you guys once you moved into the marital residence?
Yes.
Okay. And so if you guys started dating in around May of 2021, when did you guys get engaged?
We got engaged about a month into dating.
And when did you start discussing the possibility of a prenuptial agreement?
Well, we started discussing a prenup a little between he and I, just even before getting engaged, like, talking about if we were to get married, we would want to have a prenup. We both agreed. And then once we got engaged, we started talking about, let's start getting the prenup going.
Do you remember who initially raised the idea of a prenup?
I believe it was both of us. It was mutual. It was definitely mutual.
Was this your first marriage?
No, I've been married before.
How many times before?
Once before.
Do you know if this was Mr. Guabadia's first marriage?
No, it was not.
Do you know how many times he was married prior to?
Up until January of 2024, I had been made to believe he had only had 4 wives. Then after January, when the docs were released from him being denied naturalization, is when I found out that he had actually been married 5 times.
And do you remember when you first retained counsel to draft a prenup?
Yes, it was early on. It was, not too long after we got engaged.
And did your counsel draft the first draft?
No, his attorney did.
And do you know about how long you guys negotiated the prenuptial agreement? Or did you sign the first draft?
I did not sign the first draft. We negotiated back and forth to the point where I believe around the 6th or 7th month, he and I just decided to ask the attorneys to let us discuss it and let us come with the terms ourselves. So that's what he and I did. And then we met back up with our attorneys and had them put it in legal form after we had agreed on every little point. So I would say in total, it was almost a year. So like about 10 months, a little over 10 months.
So once you guys discussed kind of the broad terms that you wanted your attorneys to incorporate, did you feel that you guys were on the same page as it related to what to include in the prenuptial agreement?
Yes, because, I don't think either one of us wanted the prenup process to break us up. We were in love, we knew what we wanted. I just had a non-negotiable, which was where I lived. And I just wanted to make sure that if anything happened where I was raising our kids, I would have interest in it or have the possibility to keep it if in case there was something to happen. So we were definitely on the same terms with the prenup.
So you said kind of where you live was a non-negotiable. Could you kind of explain what you mean by that?
So I explained to him that my first marriage, I did not have a prenup. So therefore I would have had to go to court in order to get anything from the marriage. And I ended up not going to court, which made me have no interest in the home that we had together where I raised my ex-husband's child. And so I didn't ever want to be in that position again. And so when we decided to get the home that I live in now, the marital home, I told him that that's one thing that is very important to me. That's why the prenup doesn't have like huge lump sums in it of me asking him for his assets or him getting my assets. It's just really the home and then, the vehicles and alimony, which we both felt was very fair. But it was just important to me that where I, raised the family up until this point with him, that would definitely be split because we were partners in this. And he also felt it was very important as well at the time.
And I know you said that, where you live and raise your child, your children was important to you. Is that why you guys included the provision that, if someone filed, he would be the party to relocate from the marital residence?
Well, at the time, I had left Housewives in the beginning of our relationship, but that was a decision that was made prior to signing, but I had followed through with it. I also had left Dish Nation, which was a show, and that's how we ended up having the alimony. Not the alimony, but the allowance. He was replacing the income.
Okay, guys, I just need you all to do one thing, and that is simply for y'all to hit the dang on like button. Now, we got 180 people in the chat. I just need half to be in likes. It's very simple, guys. All you have to do is hit the like button. It's not like you're your Cash Apping or your Zelling anything. It's simple. All I need you guys to do is hit the like button. That is a real simple thing to do. That is the only requirement. If I can get y'all to start hitting the like button, we can get the video moving back on. All right, if y'all can start hitting the like button, that will be wonderful. You guys, are you hitting the like button? If you hit the like button, please put a 1 in the chat, please. And thank you.
And so I was working less because I was just taking the jobs that would make sure that I was in the home the most. So I still had both of my businesses, Go Naked Hair, Pampered by Porsha. Also was doing influencer jobs. So I still was working and I still did some shows, but not the bulk of shows. Like I wouldn't take certain jobs if they had me out of the house. So we knew that the longer that would happen, my relevancy could possibly be in jeopardy when it came time to make money to be able to take over the note of the house. So therefore, for me to be able to have time to build up relevancy, be able to get a loan, we both thought it would be fair for me to, if I say I want to take the house, for me to be able to have 3 years to build up relevancy back, take whatever jobs I can take for relevancy, also build up my income and be able to get a loan, etc. So that's why in the prenup it states he maintains all of the maintenance in the house, he maintains the bills of the house, because that was a courtesy he was given to me because he knew that, I would need to be able to have time to get everything together if I chose to take the house.
And did you choose to take the house?
I did not choose to take the house. I take that wording back. But I chose to decide to get a loan for the home and change it from the trust that it was supposed to be in and put it into my name, and then give him his equity out of the house. So it still would be 50-50 split, meaning once I got the home, I would still have to pay him out of the house, his interest in the home. So yes, when I filed, I did let him and his attorneys know that I wanted to take access to the house.
All right, I'm gonna show you. All right, I'm gonna show you what's been pre-marked as plaintiff's exhibit number 41. Do you recognize this letter? Can you see it?
Yes.
How do you recognize this letter?
That's written by Attorney Kessler.
Does this appear to be an accurate copy of that letter?
Yes, it does.
And I move to tender plaintiff's exhibit 41.
Ms. Ferry, I believe you're muted if you're speaking.
Okay, yeah, I was muted. I'm sorry. And it was good what I was saying too. I'll start over. Thank you. What I was saying is I do object, Judge, on the grounds of relevance. This letter from Mr. Kessler to myself, August 20th of 2024, certainly doesn't have any bearing on this court's decision as to whether or not the prenuptial agreement is enforceable or not, nor the issues surrounding the contract. So I would object on those grounds.
Ms. Hayward-James?
I would say that it speaks to her intent to effectuate the terms of the prenuptial agreement, and that it's not just a matter of she's just trying to, extend the process, but she's still following what the terms are. The terms say within 6 months you have to give your notice. She's done just that.
I'm going to deny the objection. I'm going to allow it. I'll give it the weight it deserves.
And I think you said that the prenuptial agreement also provided that for some period of time that he would cover the expenses of the home?
Yes.
And do you recall what those expenses were?
It would be pretty difficult to name every single one, but I can start with the general electricity, gas, water, sanitation, landscaping, security, ADT security, the mortgage, the prenup states any maintenance or utilities for the home should be maintained. And unfortunately, Mr. Guabadia decided to not uphold that. And so I've been paying all of it.
And when you stated that you wanted to get a prenup this time around because you didn't want, in the event of divorce, having to go to court, was it your expectation for this to be a drawn out process, the divorce that is?
Well, again, we definitely did not want to even have to go as in depth as we did with the prenup. Like I didn't intend on it to take almost a year, and neither did Simon. And that is why partially halfway through, we were like, listen, let's just you and I deal with this prenup and then let them do it to kind of speed it along. The reason why it took long at the end too is we were waiting on like Simon's financials to finally be sent and like all of that. After we had gone through such a strenuous, long process of writing this prenup, we definitely did it on the basis of we did not want to be in court as we are now a whole year trying to fight, back and forth of what this person gets or that person gets. That's why we were so detailed. Like, Simon has been divorced more than a few times. I've been divorced before. So we both wanted to streamline the process if ever we were going to have to break up. We did not ever foresee us having to break up, but if in case we did, we spent a lot of money in the front on the prenup in order for this not to happen.
Do you remember when you filed for divorce?
Yes.
When was that?
February of 2024.
And after you filed for divorce, what actions did you take regarding the enforcement of the prenuptial agreement?
Well, I contacted Kessler's office and started to and had him file for divorce.
And in filing for divorce, did you ask for the prenuptial agreement to be enforced?
Yes, one of the main reasons that I wanted to file or feel like at the time I had to file for divorce is I needed the prenup to be enforced for protection. I had become aware of a lot of falsehoods, a lot of untruths, and I felt like I had been put in jeopardy and in danger in financial ways and in some legal ways. And I needed the prenup to be enforced and the divorce to be set into place as protection.
And at the time that you filed, were you living in the marital residence?
Yes.
Was Mr. Guabadia living there as well?
Yes.
I guess who all was living there at the time?
We all were living there together. Me, Simon, his two sons, and my daughter, and that's it.
Was it your expectation that Mr. Guabadia would adhere to the terms of the prenuptial agreement?
Oh yeah, I mean, he sent me a text and said he was not going to contest it. So and even when we talked on the phone, he said he wasn't going to contest it. So I didn't expect him to contest it, no.
And I know I think we saw some text messages earlier where it said that you didn't tell him your reasons for divorce. Did you have any communications with him around the time of filing?
Yes. Right before I filed, it was two different major conversations that led to this. Right before I filed, we were in Dubai around Valentine's Day. And I was there to do a golden visa to get a golden visa in Dubai, which I was told he wanted me to get one so that then he could get one and then other people with his company could get one. Simon had signed me on and I had signed on to do 𝐬𝐮𝐬𝐫𝐷 food group in Dubai with him. And so while I was there, after I found out, this was, like I said, February, January, I found out all of these lies, all of these things that had happened in his past that I had directly asked him about that he had lied about. So, and including a lot of the fraud I did not know about. So I was on high alert and I was on edge. And so when we were in Dubai, knowing that my name was on one of the companies and I was hearing from him that I needed to take my name off of a business company, bank account, and then Rosie, his partner, was telling me that I needed
Objection, Judge, to hearsay to anyone who's not present in this courtroom.
Okay.
Yeah, Ms. Williams, you just can't say what someone else told you.
Okay.
So just be cautious of that.
So just for the purpose of the record, objection sustained.
Oh, okay. So there were discrepancies in what I was in Dubai to do with the business. And so I asked Simon, would I be able to have my attorneys involved? He said no, and he got very irate with me. And I was afraid at that point of what he had me involved in. And later on I found out through paperwork at our home that he had lied about having a company with Rosie, which is one of Akon's wives, and etc. So moving forward, before I filed, he was going to Costa Rica, and I asked him, I was very concerned. Again, this is another international trip he was taking on that same green card that we now know is invalid, also with him not having naturalization here in the United States. So I remember texting him and telling him, look, we have to talk. I am so concerned. To the point to where when he got home, we had a conversation in the bedroom, and I told him, I said, listen, I have contacted an attorney. He's an immigration attorney. He's been doing this for 30 years, and I want you to talk to him. He has gone over your court documents from January, him being denied naturalization. And I said, I want you to hear him tell you that you should not fly because you will be deported. So I put the attorney on speakerphone. We both sat, and the attorney went through it back and front, gave him details of why from his past all the way up until that day of why he should not travel. When we got off the phone with the attorneys, Simon said, oh, he doesn't know what he's talking about. I'm leaving. I got to go to Costa Rica because I need to sort some things out with that house. And, at that point, I knew that he was not listening to me. He did not take my feelings into consideration. And I was very fearful and told him that, I don't know what will happen if you get deported. I don't have any way to do anything. So that in combination with the untruths and what I felt could possibly be fraud activity that I was involved in Dubai, I wanted to enforce. I wanted to have on record that I was divorcing him, so that if in case Dubai looked up anything, that they would see that I had found something alarming to me and I had filed for divorce.
Okay. I'm going to show you what's been pre-marked as plaintiff's exhibit number 6. It's 2 pages. I know it's kind of lengthy, but I want you to let me know if you recognize this communication, and I'll scroll back up.
Yes, that's a text with me and him.
And the date says February 25th. Do you recall what year that would have been?
2024.
Okay. And does this appear to be a true and accurate copy of that conversation from the 25th?
Yes.
And that this was after you filed for divorce?
Yes, that's after.
Okay. Your Honor, I move to tender plaintiff's exhibit number 6.
No objection to P6.
Okay, so tendered.
Okay. And so if you look at the last message that you sent in P6, was that your explanation of why one of the reasons you filed for divorce?
Yes, it's part of it, but I was also letting him know that I wanted to sit down with attorneys and give him more of the information that I had on why.
Okay. When did you first feel that he was, I know you said that he had told you that he wasn't going to contest the divorce. When did you feel that shifted in him?
Well, that would be the day that he locked me out of the house. So, him locking me out of the house would definitely be him not abiding by the prenup, because clearly the prenup states that I'm able to stay in residence. So I think that was the first sign that he was going to be difficult and go against the prenup.
And do you remember when he locked you out of the home?
Yeah, it was right before my daughter's birthday.
When is her birthday?
March 22nd. And March 22nd is also the date that I would have, the March 22nd would have been the date that he was actually supposed to leave the house. So after March 22nd, it was even further more making me know that he was going to go against the prenup, because that was the date that he would have been leaving the house himself. And in fact, he was locking me out.
And when he locked you out of the home, was he residing in the residence?
One time he locked me out of the house a total of 3 times. The first time, I can't say if he was there. I know he was using his nanny to lock the house, because that house has a gate. So he was having her lock me out and change the codes and change the keys and change the locks.
Was he in the United States at that time, to your knowledge?
No, I don't believe he was.
Was he still in Costa Rica, or you don't know?
I believe at that point he was in Dubai.
Do you know, so at that point when he was in Dubai, did he ever return physically to the marital residence?
Not to my knowledge.
Do you recall him saying that you abandoned the marital residence?
Yes, because one of those occasions that he locked me out, I called the police. This particular time he was there, and I heard him tell the police that I wasn't supposed to be there and that he wanted me out.
I believe this was already tendered. Plaintiff's Exhibit P7. I'm gonna share that screen. When we scroll down to the September 23rd message, can you see that?
Yes. March 23rd?
Right.
Yes.
So was this the second or the third time that he locked you out by this time?
This was the second.
Okay. And what was the time after that?
I can't remember exactly.
Okay.
But it was about the time.
So after that, do you know if he remained in the United States?
After the second time he locked me out and the police were called to the house and we were in the house together, after that, I do not recall him returning to the United States and going to the marital property. After we got the order that told him that I am supposed to be in the house and I do have 100% exclusive access to the house, he never came back to the house. And that was on his own, that was his own option to do, because he was welcome back to the house. The judge had not said that he could not come back. He just never came back.
And the order that you're referring to, are you referring to the temporary hearing order?
Yes, that allowed me access back to the house.
And what else was ordered, if you recall, what else was ordered under that temporary order?
Under that temporary order, the final order, because that day she said that I could go back, but the final order that she put into the system was that he would have to let me know at that point if he was going to be coming back to the house. I think he had to give me notice.
And when you're saying coming back to the house, you need to stay overnight, or?
If he was going to come back and retrieve anything from the house.
Okay. And was there anything in the order about the expenses that were to be paid?
So at that point, yes, the judge did make note
Okay, guys. Now I know I don't want to keep saying this. Please hit the like button, y'all. This is YouTube. This is how we get paid. You know, like I got up at 6 o'clock, went to the courthouse, paid for parking twice, was starving. The least and the only thing I want y'all to do is hit the like button. I'm not putting my Cash App. I don't have Cash App, by the way. I'm not going to tell y'all to text me, send me money or none of that. All I need you all to do is hit the like button. Now it's 442 people here. Now at least half should be hitting the like button. If not, I'm just going to stop the video because that's the least y'all can do. All y'all got to do is hit the like button. That's all you have to do. Because if you don't hit the like button, then you don't like it and we ain't going to play it. It's simple. So can we get the likes up? I really appreciate it. And thank you in advance.
That even though at that point in time, the prenup had not been enforced, that she was very clear on he needed to still maintain all of the utilities and the maintenance, and the mortgage, and taxes and everything associated with the house. So she basically took the portion of the prenup where it states he's supposed to uphold everything for the 3 years. For the 36 months. She used that and basically said that he was supposed to maintain that.
And did he maintain those? Or has he maintained those?
No, he hasn't maintained it. No, he was paying the mortgage up until about maybe 2 to 3 months ago, and which he stopped, and then I started paying the mortgage. Utilities and maintenance, he stopped paying those like almost immediately, some of them. The water and electricity he paid for a little bit longer into the process, but other maintenance, he just stopped paying it.
Okay. I'm going to show you what's been pre-marked as plaintiff's exhibit number 29. Do you see this document?
Yes.
Do you recognize this document?
I do.
How do you recognize it?
That's everything that I've been paying.
So,
the total expenses.
Does that appear to be true and accurate through today?
Yes.
And I move to tender plaintiff's exhibit number 29.
Judge, I would object to P29. It appears to be a compilation of a summary of something or a set of documents or something that's not available to me today that Ms. Williams has used to create this document. If counsel is trying to tender this as such, what it looks like it is, I do have the right to be able to have access to whatever information, whatever documentation she used to come up with these numbers, so that way I can properly cross-examine her on cross-examination if need be. So I would object as this, for now, to P29 if I don't have the supportive documentation for P29.
And Your Honor, I would say that, I think it's pretty clear that it's a spreadsheet. I'm intending to tender it as a demonstrative of the expenses that Ms. Williams has had to cover. I think it speaks not only to intent. We've tendered evidence earlier that he said, I'm not going to give anything away for free. I'm going to have to use the good old American legal system. And I think it kind of speaks to his intent as it relates to his desire to set aside the prenuptial agreement.
What about, I think in Ms. Ferry's objection that the underlying evidence used to compile the demonstrative exhibit is unavailable, or is incomplete, I should say.
Would she want the invoices from the companies?
I just have no way of cross-examining her as to the truth of this, or when it was. I'm almost forced to just kind of take her word. So that's why the evidence.
Hey guys, I just want to jump in to say this. So what Porsha has provided is like a spreadsheet, and she's saying she paid all of these expenses. Simon's attorney is just asking her for the proof. What y'all gonna learn is what Porsha is saying that she paid. That's not the correct amount. That's why when some people were saying she said she paid the mortgage, I don't know how you can pay something and don't know how much you actually paid. Now, Porsha testified and said it was like 20,000. When Simon testified, 20,000 didn't even scratch the surface. And I said that. I just wanted to jump in and kind of clarify that.
This rule allows
Well,
for.
some of these I couldn't get the.
I'm sorry,
Wait,
Ms.
Ms.
Williams.
Williams.
This is an argument
Oh.
between attorneys, Ms.
Oh,
Williams.
sorry.
Yeah,
Yes.
I'll withdraw it for now.
Okay, all right, she's gonna withdraw. All right.
Ms. Williams, have there been expenses that you've had to cover that were ordered under the temporary orders?
Yes. Almost all of them, and a lot of them I was paying that were still in his name, and that's why I wasn't able to get any type of some of them they're still in his name, but I still found out what the companies were and paid it anyway.
Are there any other expenses that you've covered of his that weren't ordered?
Yes, I paid his child support for his 2 sons, and I also paid maintenance for the house, so that's outside of utilities as well.
Why did you choose to do that?
Well, I really got concerned being that Simon was still detained when it comes to his child support. I'm still married to him at the end of the day, and I just really felt it was unfortunate that they weren't getting any help. The mother had reached out to my assistant and that she was concerned, and she wanted a couple things from the house, but she sounded really concerned. So when I spoke to her, she made me aware that it had not been paid, and so I paid it, his child support.
Have you spoken with him since, I know that we saw a text message from March 2024, but have you spoken with him since then?
No, I have not.
Has he reached out to say, thank you for covering these bills?
No, he has not reached out at all. The last message to him from me was telling him that my daughter Pilar, his stepdaughter, had asked about him, and he left us on red. He didn't respond, so that's last.
And you would like for the prenuptial agreement to be enforced. Would you like for the prenuptial agreement to be enforced? Let me rephrase it that way.
Yes.
And why is that?
Because it's what Simon and I agreed on. It's what we wanted. So I believe that it was fair. I believe that we both wrote that prenup in love at the time and in fairness. And so I believe it should be enforced.
And do you have an, by asking for it to be enforced, what would you want done with the house?
I only want what's done, and I only want what the prenup says, word for word. I don't want, and not asking for anything outside of the prenup. So when it comes to the home, I am asking the court to allow me my right within the prenup to say that I will take access of the home. I will get a loan on the home. I will give Simon his equity, his half equity in the home.
Okay, let me kind of jump in here because I see y'all saying that you guys don't know if she actually paid. So, and that's pretty much what Simon's attorney was saying. It was like the court hearing was so crazy. There was no proof of nothing. So it's like, I paid this. Where are your receipts? So I don't know if she paid it. I mean, she could say she paid it, which she did, but there was no proof. So it's like, why are we talking about things in which we have no proof? Anybody can put a spreadsheet together. My concern is she could have paid the child support. At least she knew how much it was, but she said she paid the mortgage and all the other bills associated with the house but didn't know how much it was. So that was kind of crazy to me.
Home. And that's it. That's one of the main things. The rest of it is, of course, alimony is in there as well. And there's some other things that I think at this point will have to be paid.
Do you have any concerns that he, you know, even if the prenup is entered, that he won't transfer the home to you?
Yes, he's told his friends, really close relatives, that he had no intentions on
Objection, saying, repeating.
Yeah.
I'm gonna
Go ahead, Ms. Ferry, with your objection.
I'm sorry, for the record, I'm gonna object on Ms. Williams repeating anything that she's saying friends and family allegedly told her that Mr. Guabadia said, because that would be a two-layer hearsay. Before we even get to any alleged statements by him, she first has to find some sort of exception for individuals, which there is none under the hearsay rules.
Ms. Hayward-James?
I apologize.
Okay, all right. So, sustain the objection. It's hearsay. Let's move on to the next question.
Would you want the court to title the home in your name to facilitate the prenup?
Contrary to what Simon has been putting online, that he will fight for the house, Simon has put online that he does not want me to have the house. I believe that we should uphold the prenup, and if I am saying that I want to maintain and keep the home, that I should be able to.
And to your knowledge, did he, I believe under the did he transfer the interest in the prenup into trust with both of you all named as beneficiary?
No, he did not.
Do you want the judge to transfer the title to you?
Yes.
And do you have an idea of how much you have spent on attorney's fees?
I think at this point, with all the back and forth, just to today, not including even after today, I believe about $240,000.
And are you asking the court to, if they enforce the prenuptial agreement, for the court to reimburse those expenses that are related to you defending the prenup?
I pray the see fit to do so and pay for those expenses.
And if there are any expenses that Mr. Guabadia did not cover under the temporary order, are you asking the court to reimburse those expenses?
Yes, there's a little over $85,000 worth of maintenance, utilities, and mortgage that I've paid to maintain our home. Our home would be in foreclosure if it wasn't for me paying these bills. I'm paying the mortgage at this point.
Did you pay the June mortgage?
Yes.
Do you know about how much that is a month?
In total, a little over $20,000.
Okay, so I just want to jump in there. Y'all heard her say that what she paid was a little over 20,000. Now, just remember that, because when Simon testified, y'all gonna say, how could she mix 20,000 up with over 50? They are not even in the ballpark amount. So that's why I said, how did she pay that when she didn't even know how much it was? So when you hear Simon's testimony, he'll say that the monthly bills to pay the mortgage and the upkeep is well over 50. So where did she get 20 from? That don't make sense.
The 20,000 a month?
Not exactly sure, but I believe it's somewhere between 18 and 20,000, I'll say.
Okay. And have you been covering the landscaping expenses?
Yes, I have been maintaining all of the maintenance inside and outside of the house. Just to be clear, the order that the judge put in prior to that gave me access to the home mirrors the prenup, where he's also supposed to be taking care of maintenance, like when the elevator went out and it's a couple $1,000s, or the sink, or the water, or leaking, drainage, anything at the house, and I've been maintaining it all from my finances.
Your Honor, if I could just have like 2 minutes to confer with my co-counsel to see if there's anything I missed, that would be much appreciated. Thank you, Your Honor.
She's on her way back to her office. I think we're done.
Oh, so you're finished?
I think so. She's stepping into her office right now. She just may have one question, I think.
Have a pretty long hallway. All right, thank you, Your Honor. Yeah. May I proceed?
Yeah. Yeah.
Okay, I couldn't see, sorry. Lastly, Miss Williams, do you defer to your counsel to testify in further detail as it relates to your attorney's fees? You're on mute.
I can hear.
Okay,
Miss Williams is on mute. Okay.
Yes.
I was on mute.
Did you hear my question? I can say it again.
Well, yes.
Will you, do you defer to your counsel, Randy or I, to testify further as it relates to your fees?
Yes, please.
Your Honor, I have no further questions for Miss Williams.
All right, so Miss Ferry, what do you want to do cross now, or do you want to wait till it's your case? How do you want to handle that?
I would like to do cross now. And the reason being, I don't know if counsel plans on raising the same motion for a directed verdict again. So that's why I wanted to go ahead and do cross. Or the court's looking at me like, I mean, I could start.
No. If you're interpreting my look, it's inadvertent because I'm ambivalent as to whether you want to do cross now or whether you want to wait until you do your case in chief. But
yeah, the reason I want to do it is I'm just anticipating any motions or oral motions.
Okay, well, you don't need to even offer an explanation. All you need to do is say I want to do cross now, and I'm good with it. So
I'd like to do cross now.
Well, Your Honor, we're not resting, just to be clear, because we got to put up the fees. We just need a 5-minute. The only other thing we have left is Ms. Hayward James is going to spend 3 minutes just submitting the bills to verify the fees. But it'll be a 3-minute thing. We can do it after the cross or before, but I didn't want the court to think we rested without having submitted our official evidence of fees. That's
okay, all right, fair enough. We'll keep that placeholder open, but Miss Ferry, go ahead with your cross.
Okay. Good afternoon, Ms. Williams.
Hello.
So I just wanted to ask you some questions about your testimony. You just testified, I'm just gonna start with some of the latter things that you testified about. You testified about incurring attorney's fees, for example, of $240,000+, correct?
Yes.
Okay, are you familiar with the terms of the prenuptial agreement?
Yes.
Okay, I'm going to show you what I have. I have it pre-marked as, okay, I have it pre-marked as Respondent's Exhibit 13. It's a 200-page PDF that you should see on your screen that says prenuptial agreement. Do you see that on your screen?
Yeah. Or contemplated divorce. There is where I write that I'm going to put it in writing, and so that we can talk about this decision. Also, when we're on the phone, I told him as well that I want to.
Okay, guys, the reason why I just kind of went past it, because some of this has their address on it. So that's why I have to watch, and I have it like written down those points. So they're going over the prenup, but I kind of went up a little bit because some of those documents does like have their personal information on it. So that's why I went, over that. So continue.
Sit down with my attorneys and explain to him what's going on. You're calling it mediation. I'm just a lay person. So no, I'm not going to automatically know to say mediation to him. But I did say that I wanted to sit down. And I feel, my personal opinion, is that it didn't happen because things got really bad. My personal opinion is that it didn't happen because things got really bad with how he was treating me at the time.
Okay.
But I'm still not sure if maybe the attorneys requested it or they did not. I'm not sure.
Oh, I'm only reading the document. I'm not adding any words. Or did you have $240,000 in attorney's fees during that time?
Well, I knew that I would have upward to almost $200,000 in attorney fees because Randy Kessler is not cheap. And
I'm gonna object. I'm taking over the objections from Ms. Hayward-James. She's not, she's asked me to do that. We object, number one, to the
Judge, I'm sorry, Judge. Rules require one counsel examination. So
Yeah,
it'll just be me.
You're gonna have to let Ms. Hayward-James do it. I mean, she's the one who had her on direct, Mr. Kessler.
But I also raised this issue at the opening, Your Honor, that when they argue things, they're arguing that she's violated the agreement that they're saying is not enforceable.
Mr. Kessler, I don't mind addressing that. I mean, they're going to have a fallback, but I don't fault them for going down both roads, because I mean, if I rule the motion and enforceable, she's got to have a fallback position. So, but you're going to have to let Ms. Hayward-James handle these objections. I mean, she's the one that did it on direct. So go ahead, Ms. Ferry.
Ms. Williams, so I was asking you, because you testified that the fees are $240,000, as we sit here today, that you spent. So what I'm asking you is, a year and 2 months ago, April of 2024, did you incur $240,000 April of 2024 in attorney's fees? Did you incur that at that time?
I knew I was going to incur upwards of 200 plus or more attorney fees after March 22nd.
Ms. Williams, remember what the judge mentioned to you earlier? You have to answer yes or no and then explain.
Yes.
Because it's not clear what your response is, ma'am.
You have to answer the question, Ms. Williams, and then you can explain.
I don't think I understand the question.
Well,
in April,
are you asking me that just 6 months was it? Are you asking me what is the time frame? Are you asking me was the 250?
I believe the question was, by April of 2024, had you racked up $240,000 in attorney's fees with the Kessler's firm? Is that correct, Ms. Ferry?
Yes, that was my question.
I can't be sure.
Okay.
So, as it relates to, I'm not going to beat a dead horse, but I do need to ask you this question. You are aware that the temporary order also required the parties to attend mediation. Are you aware of that?
No.
And if you're not, you can say no. Okay.
Not at the time.
One of the things you testified about, Ms. Williams, you indicated that there was some concerning behavior that caused you concern regarding Mr. Guabadia. Do you recall that testimony that you gave to the court saying that you saw some documentation or you saw some things that caused you some concerns regarding an illegal business or something to that nature? Do you remember telling the court that?
Yes.
What illegal business are you referring to that was concerning to you?
So I later found out in Dubai, the company that Simon partnered with me on was a shell company. It was not a real company. He also had not let Dubai know about his U.S. status at that point, that he did not have a green card, valid green card, or naturalization in the U.S. He did not mention being a U.S. citizen. He used only his Nigerian identification at the time. And I was warned that by doing that business and not able to get any information from him or the people who worked with making that company happen, that I would not be able to pay taxes for that company in Dubai, because as an American, I would have to pay taxes for any company in Dubai. And even since filing, I have asked for that information and have not received it. I also was denied the possibility to have my attorneys look over all and any of the Dubai business documents that I had signed. When I asked that, he told me no, and he got very irate with me. And quote, he said, "F it." And so at that point, I was, of course, very afraid because I'm doing business in Dubai, signing paperwork, and not able to have any legal representation.
Ms. Williams, could it be that you just didn't understand the business operations in Dubai?
No, whether I understand, I asked questions.
I just want to say this. How do you continue to call somebody a scammer, but still wanting them to pay? Because if they're a scammer, then how do you, this just don't make sense. She's calling him a scammer in essence, but yet want to enforce a prenup. This girl, Porsha, is 265 days a year.
And I got answers, and the answers that I got were not true. I asked, was the company that I was a part of going to move forward and operate? He said yes. Found out later it was a shell company. I asked him, would I be able to have my attorneys or hire a Dubai attorney to look over that paperwork? And he said no. I asked for banking information. He would not give it to me. As I was leaving Dubai on one occasion, he told me that he was putting my name on a condo or home, and I asked him not to. That was also done without my knowledge. So all of these things were happening right after I found out his pretty, to put it, sketchy past. And so it was very alarming to me. But up until that point, I had trusted my husband. You know, I loved him, and whatever he was asking me to do, I thought that I was gonna be protected, only to later find out that I was not.
Are you still in the marital residence as we speak?
Yes, I am.
Who lives there with you?
My daughter.
You mentioned that you made the mortgage payments to the marital residence. To your knowledge, are the mortgage payments caught up?
Yes, I believe so. I would have to check with my, yes, and I would have to check with my accountant to make sure that June is paid.
When is the first time that you made the mortgage payment to the marital residence?
I believe it was about 2 months.
You've paid 2 months?
I said I believe so. I believe it's about 2 months, 2 or 3
Okay.
months.
When did you pay the 2 or 3 months is my.
So y'all pay attention to this line of questioning. Do y'all see how she's getting irritated when she's just asking, did she pay or how many months? This is why I'm telling y'all she couldn't have paid, because you would have said, I paid this month, I paid this much. She's like, I said, you know, she's giving attitude.
Question. When did you make that payment?
Sorry, I didn't mean to cut you off.
No, go ahead.
Okay, yes. When we came to court, the last time we were in court, I heard you mention that, you know, why doesn't Miss Williams pay mortgage? You know, if she wants the house, won't she pay the mortgage? And I was like, well, why don't I pay the mortgage? If it's in jeopardy, let me find out. And I, in fact, left court and got the proper information, and I followed what you said, and I, in fact, paid the mortgage. Started paying it then at that time. I can't remember if it was a month behind already, so then I ended up paying 2 months, or whether I paid 1 month and then paid the next month, and now June would be, this month is what I may have to pay. I'm not sure. I have to check with my accountants.
Okay, and how were you able to make that payment? Did you mail it in? Did you call it in? How did you make the payment?
I would have to ask my accountant. He paid it for me.
You also mentioned that you paid Mr. Guabadia's child support. When did you do that?
I paid his child support after he was detained. His ex-wife contacted me about his sons, at the time I felt our sons, who had lived with us, and said that she, you know, wanted some things from the house. And I ended up talking to her, and she told me that she wanted, you know, that he had not paid it. And, you know, she was very concerned, so I paid it. So that was, I can't say exactly what month that was. I can look at text if that's okay.
How much did you pay her?
His child support had been raised, so I believe it was around $5,200 or $5,300.
And
But
you
it was
mentioned
before our last court date.
You mentioned that your goal is to refinance the marital residence. Have you started the process to attempt refinance?
I am starting the process to get financing for whichever way this goes.
Do you have a approval letter for financing?
Yes.
And what were you approved for? Like, how much were you approved for?
I'll have to get the exact amount from my accountant.
And that's another red flag. How do you not know how much you was approved for? Who don't know that? Like, this is why she was asked about her mortgage, but she knows nothing about the new loan that she claims. If you don't know the interest rate, which she wouldn't because they changed, you don't know how much. You would know if they say, we're going to give you 1 million or 2 million, because you know you got to come up with the rest. But the fact that she don't know anything is a clear indication that this girl is lying.
When did you receive your approval letter?
I would have to get the exact time from my accountant.
Is it correct that you mentioned earlier that you had a premarital home located in Duluth, Georgia? Is that correct?
Yes.
Okay. Do you still have that premarital home in Duluth, Georgia?
Yes, and not for long.
Y'all see that? Not for yes, not for girl. Get it together. This girl is lying.
I did not have a prenup.
Wait, I'm sorry, y'all. I went too far.
Ms. Williams, you are a celebrity, correct?
Yeah, I think I went a little bit too far. I'm so
Testify to the rates. That'll be 5 minutes, and that's it.
Okay.
I think I swear.
I am so sorry.
Hearings and we confer a lot, but we try not to double bill, and we take that into
In for a couple hours tomorrow morning. I'm just trying to get a feel for things right now.
Your Honor, Miss.
I have I think I have a short witness. It's probably going to be less than 30 minutes. I mean, it depends on the pushback I get from the opposing party, but.
Yeah, I'm trying to get back to where we was. I hit something and it took us back.
Television and live streaming, you receive that money through a company that you own.
Okay, I think we were right here. Okay, I know where we were now.
Not from my accountant.
Right here.
When did you receive your approval letter?
I would have to get the exact time from my accountant.
Is it correct that you mentioned earlier that you had a premarital home located in Duluth, Georgia? Is that correct?
Yes.
Okay. Do you still have that premarital home in Duluth, Georgia?
Yes, and not for long, because my new loan requires me to sell that particular property.
I want to show you what is pre-marked as Respondents Exhibit 13. Okay, do you see Respondents Exhibit 13 on your screen?
Yes.
Okay, I'm just gonna scroll down so you have the benefit of seeing this entire document. Okay, did you see your signatures on these documents? Do you see your signatures there?
Yes, that looks like my signature.
Okay. Let me scroll that to the top. And this indicates that this is a limited warranty deed dated September 20th, 2016, granted to Porsha D. Williams. And then as it relates to the property, it is the property in Gwinnett County or Duluth that you referenced. Let me scroll down to that actual part. Is it the 26?
All right, y'all. StreamYard is acting a fool. It done took my entire video out. I am so sick of StreamYard. Child, what just happened to the video? All right, just give me a second. It just disappeared. The entire thing just disappeared. All right, y'all. I got to get it back up. Just give me a second. Give me.
I'm just trying to keep a little control over it. So that's actually why I'm sitting out in the courtroom right now, because I knew this.
All right, I got to go back to where we were. Just give me a second, because we were way down here. Just give me a second here.
March.
Television and live streaming, you receive that money through a company that you own called 𝐸₂. Ms. Williams, you are a celebrity, correct?
We had the status conference on the 4th.
All right, y'all. We'll get to where we
Okay. And as far as the accumulation of the 200,000+, looking at this, it doesn't look like, as of April 30th, for example, of 2024, that your firm had incurred.
All right, y'all. Let me get us back to where we were.
I mean, I think so. He will testify to. He's an entertainment attorney, and so he's an expert when it comes to entertainment attorney and contracts law, or contracts related to TV, film, production, and all of that. So that's why I say he's going to be a quick witness. I don't think it'll be long, but there's nothing that has been filed in this case that would prevent me from offering Mr. Honore as a witness or even an expert witness, because we went through the same thing with Mr. Bates. I was not notified. It was trial by ambush at a discovery conference about an expert witness. So.
All right, so you think that he's gonna not be very long, and in your client's an hour. Let me ask you, do you have an opinion as to whether you want to just try to wrap this up, go late tonight, or come in tomorrow morning and do this? Because I'm starting to get tired. But
I would say, Your Honor, just to help with scheduling, we do have one matter. It's by Zoom. It's a 10 o'clock juvenile matter for 10 o'clock. I can't imagine going more than an hour, 10 o'clock to 11 tomorrow, but that's the only thing I have tomorrow. I would not put a conflict. I would put a conflict letter in if I but.
I do have, I mean, of course, we're in trial, so it would take priority. I think I have a mediation tomorrow. I believe we start at 12 or 1. I'm logging into my calendar now, but I would prefer to finish it this evening, Judge, but
let's do our best then. Let's go ahead and roll with your case. I can't guarantee we're gonna finish it, but at least we'll try to get it.
Okay.
Get a chunk.
And if I'm asked, I don't mind, but should I tell my 6:45 appointment that should I find a way out of that just to be safe, or will we definitely be done by 4?
Let me check with the court reporter. Shauna, where are you at on this?
You're the boss, Judge.
All right, well, let's keep rolling, and Mr. Kessler, I guess, tell him Let's try to get this finished tonight.
All right, I'll get off at 7 o'clock, whatever it is. Okay, 6:45 thing. Okay.
I call, may I proceed, Judge?
Yes?
Okay, I call Mr. 𝐼𝐶.
Good afternoon, or should I say good evening?
Yeah.
Good evening. Should I swear him in, Judge, or did Your Honor want to swear him in?
I'll go ahead. I've been doing it to be consistent. So, Mr. Honorary, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth in the testimony you are about to give?
I do.
And can you state your name and spell it for the record?
Sure, my name is 𝐼𝐶. First name spelled ALCIDE, last name spelled HONORE.
All right.
Are you a licensed attorney in Georgia, Mr. Honoré?
Yes, I am.
How long have you been licensed as an attorney?
Approximately 16 years.
Okay, and can you explain to the court what your professional background is?
Sure, so I've worked extensively in both transactional and litigation matters related to issues involving entertainment contracts and various aspects. I am a member of the IP section of the Georgia Bar and co-chair of the Copyright Committee. If you guys are free Friday, we actually are doing a CLE all day. And I have worked not only in representation of clients or on-camera talent, but also on behalf of productions and production companies, including production companies that have serialized programs in global distribution. So I have, extensive knowledge on the nature of the interests that are sacrificed or exchanged in return for compensation as it relates to the participation of individuals in television and film programs, especially those that fall into the space of what's commonly referred to as a reality or docu-follow.
Your Honor, I don't know if our colloquy was off the record, but I do want to make sure we interpose our objection to this witness as to relevance. This is a motion to enforce a prenuptial agreement, not an entertainment contract. So I imagine Your Honor's going to wait until you find the time to decide if it's relevant or not, but I want to make sure on the record we're objecting to the relevance of this witness from what I've heard so far.
So, Ms. Ferry, that question was entering my mind as well. What is the relevance?
Yeah, Judge, I was trying to lay the foundation, and then I was going to take a break and pause and then allow the court to address it. So essentially, what I plan to argue in a closing argument is I do plan to cite the case law as it relates to contractual principles for the court to weigh in and determine whether or not the contract at issue is in fact an enforceable contract. Essentially, what I anticipate this witness will testify to is I anticipate that he is going to testify to the nature of the type of contracts that reality TV stars, entertainers such as Ms. Williams enter into, and that the terms of the contract, or by entering into the terms of the contract, just by nature of the provisions, she would contract away the rights and interests that she would have in the prenuptial agreement. In other words, she would have to, by essence of signing the truly original contract in that agreement, she is in essence taking action against the prenuptial agreement because she is now contracting one right away for the benefit of another contract. In other words, just by her mere entering into that contractual agreement, it violates the prenup, thereby making it unenforceable. And I plan to, cite to some case law and some argument to the court in my closing. So that's why he is here to add that level of expertise and explanation to the court so the court can fully grasp and understand the magnitude of the issue that is at play here.
I renew my objection to relevance. This is not an entertainment contract. The court's determining whether to enforce a prenuptial agreement. If there are other remedies or actions or whatever they want to file, but
I'm going to, based on Ms. Ferry saying it's going to be very brief, I'm going to, and at some point I may decide it's not relevant and cut it off, but I'm going to allow it, only that Ms. Ferry has presented a theory that I've been, I don't want to open the door too much to, but almost a fourth prong here now that given the fact that there's allegations that the contract hasn't been, the prenup hasn't been adhered to. But Ms. Ferry, let's go ahead with it.
Okay, well, I'll just jump to it then. I move to tender Mr. L.C. Honore as an expert in entertainment law and scripted TV pursuant to OCGA 24-7-702.
And I renew my objection. Mr. Honore is certainly an expert in that field and certainly well respected, although I don't think it's relevant in this matter.
Okay, well, I'm going to overrule that objection and let's go ahead.
So Mr. Honore, I'll ask you, I'll just jump straight to it. Can you explain what privacy rights reality TV participants typically waive when it comes to their talent agreements or contracts?
Sure. So the only thing that, generates value for the broadcast company or the producer of these particular agreements is, the rich, interesting, and full lives of individuals that appear on screen and the extent to which their engagements, with friends, families, and their own, experiences in life are interesting enough to command the attention of the millions of viewers that are required to make these programs profitable and worthwhile. So to the extent that there is any opportunity for these specific sorts of shows to be successful, these are not, sort of scripted actors that are delivering particular dialogue. They're individuals that are essentially selling, the things that take place in their life, in their personal life and private affairs. And so it is through waiving their, property interest in all of those particular things that they are able to deliver value to the company that is actually distributing the program that they're appearing, without providing those rights and that access and that control. Then there essentially is nothing of value that they are providing, in the way of any sort of scripted performance or anything of that nature.
May a participant forbid or prevent producers from filming or airing certain topics?
That's very unusual to occur for a number of reasons, one of which is that these grants of rights tend to be perpetual in nature, and there are a number of different formats or ways in which these shows are distributed, whether it's through a linear broadcast, on demand. These programs and the footage are often cut, redistributed, aired on subsequent, versions or serialized editions of these programs and so forth. So it is, certainly relevant to the value that an individual is able to drive to the party that is paying them for their engagement to be able to turn over those rights.
I mean, the problem that I have with this testimony, Ms. Ferry, is that you've got an expert that is essentially, based on his expertise, speculating what in his opinion is probably in Ms. Williams' contract, because you don't have the contract. And I know you're going to say, well, because you wouldn't allow us that. And of course, that gets back to the circular argument about what you, I guess, object to my characterization of it as a discovery waiver. But it is where we're at right now. And of course, Ms. Williams has testified. It's somewhat similar to what Mr. Honore is stating in that look. These reality shows, they're all into the lives of to their lives, and they give the people interesting tidbits and whatnot. But Ms. Williams' testimony was, there's really no requirements in my contract, but it's going to put me in a disadvantage or a difficult negotiating position, or they may not even want me in the next step for the next year. So I'm really, I feel like you're trying to backdoor testimony regarding her contract is based on speculation here, and it's not very compelling to me at this point.
Okay, I do have just one question. I don't think it'll run afoul of what the court is already, I guess, kind of ruling, so to speak, Judge. I do have one last question for Mr. Honore. I can ask it, and then
Sure.
the court. Okay. The question that I would just jump to is, Mr. Honore, can a reality TV contract exist or coexist with a promise to keep marital matters confidential? That's my question to him.
Not in my opinion.
Objection.
I have
Well, Mr. Kessler's got an objection.
My objection is speculative, it's hypothetical, and it's not based on the facts of this case. But, yeah.
I'm going to overrule
I'm
the
happy to
objection.
finish.
I'm going to we've allowed him in as an expert witness. I'm going to give the evidence the weight it deserves. I made my opinion known just a few minutes ago, but I am going to allow the question, and he's stated not in his opinion. I don't know if he has anything more to add to it, but.
Sure. So in my very recent experience reviewing contracts with this particular network and production company, there is not a scenario that I'm familiar with where those contracts could exist without being in direct tension with one another.
All right. Thank you, Mr. Honore. That's all I have, Judge.
Any redirect, Mr. Kessler?
One question. Mr. Honore is an entertainer.
And I'm going to give a shout out to Mahogany. Thank you so much for the super chat. I really appreciate it. If you guys are in here, all you have to do is hit the like button. But thank you, Mahogany Blue, for the super chat.
Entertainment lawyer expert, familiar with this network and this show, Real Housewives of Atlanta. You would agree with me that it could significantly hurt the career of one of the Real Housewives of Atlanta were she not able to film in her house as a Real Housewife of Atlanta, that there could be some significant harm to her career and future finances?
Certainly, to the extent that someone's ability to disclose and communicate issues regarding their personal life in all, manifestations of it, certainly could impact the financial value that they're able to drive to the network. There's an exchange, right? As you know, Mr. Kessler, you're not worth that large dollar amount per episode if you're not giving juicy and interesting commentary. So to the extent any element, the one specifically you mentioned with respect to the home and any other element of someone's personal life, is interesting. Right? All that speaks to the value of their ability to participate on these programs.
Thank you so much.
You're welcome.
You have, I referred to it was your direct. I think I called it redirect with Kessler, but it was actually his cross. And so now, Miss Ferry, do you have redirect on Mr. Kessler's one question across?
No, Your Honor, I do not.
Okay. All right, Mr. Honore, you're excused.
Thank you. It's been very interesting, but I appreciate you excusing me, Judge.
I don't know that I agree to him. Never mind. Big release.
Okay, your next witness, Miss Ferry.
I call Simon Guobadia.
Okay. Well, Mr. Guabadia, you're already under oath from when Mr. Kessler called you.
Now, guys, Simon is going to testify. Now, this is going to make a lot of sense for y'all because some people was inboxing me saying that the income that they're saying Simon has was income that Porsha and her attorney made up. That is absolutely not true. I went to the court hearing simply because we can read stuff online. However, their prenup is not online. You are not able to read it. Simon is going to testify to what his income is. In fact, Simon's attorney was the one that did not care about his, income being released. It was Porsha that did not want her income to be released. So you guys probably can't tell, but I had to cut the camera off when Porsha talked about her salary. And then the judge said, you have to promise not to say that on your podcast. So, okay.
On cross, so you can go ahead with your questions, Ms. Ferry.
Yes, Your Honor. So, Mr. Guabadia, I'm just gonna kind of jump to, I'm gonna try to stick to those matters we haven't heard yet that would be in conflict with your testimony. So, there was testimony earlier that you started dating Ms. Williams in May of 2021. When did you all actually start your relationship?
We started on and about April 7th of 2021.
Okay. And what were you doing for work at that time when you started dating her in April of 2021?
For the last 15 years, I've been the chief executive officer of the petroleum company, 𝐮𝐬𝐫𝐿 Petroleum.
And are you the sole member of 𝐮𝐬𝐫𝐿 Petroleum LLC?
That's correct.
Okay. And is 𝐮𝐬𝐫𝐿 Petroleum LLC U.S. based and operated?
100%.
I think you testified earlier that, well, there was testimony earlier. I'm not going to say who said it. I can't recall, but there was testimony earlier that at some point in 2021, Ms. Williams did leave her job with Dish Nation and Real Housewives of Atlanta. Do you agree that that did occur in late 2021?
I would say it occurred sooner than that.
All right. So can you explain to the court what the
Thank you for the super chat, Diamond Eyes. I really appreciate it. Thank you so much.
discussions you had with Ms. Williams as it related to her leaving her employment from Dish Nation and Real Housewives of Atlanta?
I would characterize that to be one of the most difficult seasons for her on the 10 years that she was there, and she was essentially had decided to take what she called a mental break, and that she did not want to do that anymore as far as the Real Housewife was concerned, and she just wanted to travel and enjoy her life.
Okay, guys, I'm going to jump in there. And I believe Simon, if he doesn't say it in this testimony, he said it in previous. Simon said that he knew Porsha for 10 years. Now, he did say this. He said he knew her because they had shot scenes at restaurants that he had. But then he said he didn't know her personally. So y'all, do what y'all may with that information.
But there was also the question of what, she had expenses, and she needed to figure that out.
Okay, and so at some point, were you paying Ms. Williams a monthly allowance when you all were dating?
Yes, it actually came up very quickly after she shared with me that she had no plans of returning back to the housewife. And I'm not sure how we arrived at an amount, but I think for the most part, I've figured out in my head what would cover her expenses per month.
Thank y'all so much for the super chats, the network specialists. Thank you so much.
Did she, when you say she shared with you that she had no plans of returning to the Real Housewives of Atlanta, do you recall when she shared that with you?
Your Honor, I understand Your Honor is likely to let this line continue, but we do want to put our objection in again that this issue has been resolved. It's been sort of predetermined by the court in the last order, but there's no basis in the prenuptial agreement, no recitation that the reason for this prenuptial agreement was because she said she was not going to be working, and that could have been the prenup. So a lot of questioning, in my opinion, is irrelevant. But I just want to make a record.
I'm going to overrule the objection. I'm going to let it go for right now, but it doesn't.
May I respond for the record, Judge? Just for the record. I understand.
Sure. Fair enough.
And just for the record, again, the discovery order was just that. The analysis done by this court was done for the basis of determining not the enforceability overall of the contract, but more so the enforceability, or I guess provide intent.
Okay, guys, I got to stop the video just to give these people a shout out. Thank you so much, K. Johnson, for your super chat. Then we got Sanitra Art. I hope I said your name correctly. I do not like mispronouncing people's names. I really appreciate y'all super chat. I appreciate it, but you don't have to super chat if you don't want to. But you do need to hit the like button. But I really, really appreciate y'all so much. Thank you.
I think that's what the court was looking for, the intent behind the parties when executing that contract, to then have the court put some parameters on discovery itself. But I don't think the intent of the order was to cut me off at the knees with presenting a full case on the substantive issues about the enforceability of all of it.
And that's a good point, and I appreciate you responding for the record. I tend to, when I'm ruling in favor of the other party, I can roll through it and forget to give them an opportunity to respond. But yes, I ruled on it overall from a discovery standpoint. If I didn't feel the need to do the motion, if I completely agree with Ms. Kessler, then we wouldn't be here today. We would have rolled the motion to enforce in, which I'm sure he would have been much happier with.
So y'all, I just wanted to jump in there. Did y'all hear what the judge said? The judge is simply saying that if he agreed with Porsha's attorney, they would not be there today. But I want y'all to understand, I feel like the judge really only did this hearing to appease Simon's attorney, because the judge did not, and I'm not saying he had to change his mind. I just felt like with this hearing that he wasn't going to change his mind anyways. And as y'all hear him speak, you'll hear him say certain things that'll make you be like, huh? It just seemed like from the beginning that the judge was not coming to the hearing to be objective, but just really to come to have the hearing to seem fair. I just feel like that.
But that's why we are here today. So go ahead, Ms. Ferry.
So Mr. Kessler, you were testifying about the discussion. My question to you was, when did Ms. Williams indicate to you that she had no plans of returning to Real Housewives of Atlanta?
You meant to say Mr. Guabadia, you said Mr. Kessler.
Oh, did I? I'm so sorry.
It's okay.
Mr. Guabadia, sorry, long day.
Not as handsome as he is. We started that conversation right, I would say very quickly, and I say very quickly because we were engaged within 30 days of meeting each other. Okay. So I would say it happened fairly quickly.
Okay, you said that you all were you started your relationship April 7th of 2021, and you were engaged within 30 days of that. Is that correct?
That's correct.
Okay, so that would be about May of 2021 you were engaged. Is that correct?
Yes, that's correct.
Okay, and so you said you all began your discussions then about her not returning to the Real Housewives of Atlanta. Do I understand your line of testimony correctly?
It was made very clear. I'm a fairly intelligent and educated person to understand when someone tells me I have no desire to return back to a job I've held for as long as 10 years, and I would like to do something else, but I do have bills, and I have to figure out how to do that. And if I was willing to if we were going to be married and she was not, she had bills, I think the right thing to have done, and which we both discussed, was to assist her with our expenses. And I came up with $30,000, and there was a slight pushback, and I quite frankly didn't understand on what basis. There was a slight pushback to want more, But I said, I'm sorry, that's the best I can do.
Okay. So,
Are y'all following this? They got engaged 30 days after knowing each other. I don't know. That just for some reason sounds very weird. So I also feel like maybe this was a relationship that they were getting with each other for other reasons because girl, you got a 6-year-old. Your daughter was what, 3 then? You brought a whole stranger that you were gonna marry. Something ain't right about this, y'all.
you began paying her this $30,000 per month. Do you know how long that continued?
I believe it continued into the marriage. When we got married, I was still paying that. There might have been a period in time where there were slowness in paying, and essentially that was because she embarked on this elaborate wedding that cost upwards of almost $3 million.
Okay. So I want to now talk to you and jump to the prenup. As far as the prenuptial agreement that you all executed November 17th of 2022, did you take into consideration when you executed the prenup, Ms. Williams' employment status at that time?
Absolutely. It was, I took into consideration that Ms. Williams had a daughter and had a mother she had retired. She had expenses that were essentially being borne by the major employment she had with Truly as a real housewife for a decade. And so I was very empathetic to having to step away from that situation for having been mentally dealt with a show of that type. So I wanted my wife to be okay financially and not have to worry about her bills and just travel with her family.
Is that why in the prenuptial agreement you had agreed to paying $40,000 per month in the event of a divorce?
Objection that's leading, Your Honor. When you suggest the answer in the question, it's the definition of leading.
It is a leading question. Rephrase it.
Why did you agree, Mr. Guabadia, to the $40,000 per month?
I felt we were already covered a good part of her expenses, and the idea that I would have to pay significantly more, which at the time they threw a number of $100,000 a month. I was a little taken aback by that, and I said the most I'll do is add another $10,000 to what I've already been doing, probably well over a year at this point.
Okay. At the time that you entered into the prenuptial agreement, let me retract that. I want to ask you about the marital residence. The marital residence, can you provide the address to the marital residence?
45.
I don't know how we address that, but we didn't want to seal the whole case. But
she's acknowledging that she will not disclose.
Two of my real estate properties, one in Miami and the one.
Okay, guys. So what I did is I had to fast forward because they did talk about their address and then they showed the address on the screen. So what you probably missed, because I done watched this 99,000 times, Simon said that he put down $2.4 million. So the house that is in question with regards to now, Porsha gets to sell it or refinance it. Simon testified he put down $2.4 million.
The one from my previous marriage in Atlanta.
Okay. Do you recall how much you put down on the marital residence?
Approximately 2.4 million.
Did Ms. Williams make any payments towards the purchase of the marital residence?
No, she didn't.
When did Ms. Williams begin living in the marital residence with you?
I would say approximately a week after closing.
Okay, so the home was purchased November 8th of 2021. Did she begin living with you in November of 2021 or in 2022? Do you remember?
I believe in 2021.
Okay. And who made the mortgage payments on the marital residence during the time before you all separated? Who made the payments to the marital residence as far as the mortgage?
I did.
Okay. And who paid for the utilities at the home?
I did.
Who paid for the maintenance and upkeep at the home before you all separated during the marriage?
I did.
If you had to give an approximation, approximately how much does it cost in total to maintain like the payments as far as the mortgage, the utilities, upkeep, landscape and maintenance, etc. to the marital residence?
Approximately $50,000 a month.
And approximately how much are the annual taxes to the marital residence? Do you know?
Approximately $75,000.
$75,000 per year, approximately.
Correct.
Is it correct that you and Ms. Williams don't have any children together, correct?
Now, did you guys hear what he said in terms of how much the monthly payments were and the taxes? If y'all don't, I can rewind it, but I just want y'all to make sure to pay attention because Porsha said it was 18 to 20,000, but that is not what he said. So just, I don't know if y'all heard that. Did y'all? If y'all heard what Simon said in terms of the mortgage and the taxes, put it in the chat, please.
That's correct.
Okay. Do you have children of your own?
Yes, I do.
Okay. Did your children live with you in your marital residence?
Yes. 2 of my children I have.
Yeah, I'm going to rewind it just a bit because I think y'all missed that part. Y'all missed it. So let me go back just a little bit.
2 of my real estate properties, one in Miami and the one from my previous marriage in Atlanta.
Okay. Do you recall how much you put down on the marital residence?
Approximately 2.4 million.
Did Ms. Williams make any payments towards the purchase of the marital residence?
No, she didn't.
When did Ms. Williams begin living in the marital residence with you?
I would say approximately a week after closing.
Okay, so the home was purchased November 8th of 2021. Did she begin living with you in November of 2021 or in 2022? Do you remember?
I believe in 2021.
Okay. And who made the mortgage payments on the marital residence during the time before you all separated? Who made the payments to the marital residence as far as the mortgage?
I did.
Okay. And who paid for the utilities at the home?
I did.
Who paid for the maintenance and upkeep at the home before you all separated during the marriage?
I did.
If you had to give an approximation, approximately how much does it cost in total to maintain like the payments as far as the mortgage, the utilities, upkeep, landscape and maintenance, etc. to the marital residence?
Approximately $50,000 a month.
Did y'all hear that? $50,000 a month. Porsha said 18 to 20. This is how you know she lying. When she said it, I said, girl, now look, I know that property does not cost 18 or 20. It's like double that and some. And I always said about 50, and I was right. Simon said that it is $50,000. So how in the hell did Porsha pay it when she didn't even come close? Second time that this has happened, and I don't know why. Now I gotta bring the video up again. Y'all give me a second. Oh my gosh. This is really wearing me out. Ooh. Oh boy, this is wearing me out, y'all.
Yeah, just trying to keep
it continued into the
hypothetical, and it's not based on the facts of this case. But yeah,
I'm going to overrule the objection. I'm going to allow.
It's interesting, right?
And Your Honor, I understand Your Honor is likely to let this line continue, but we do want to put our objection in again that this issue has been resolved. It's been sort of predetermined by the court in the last order, but there's no basis in the prenuptial agreement, no recitation that the reason for this prenuptial agreement was because she said she was not going to be working, and that could.
All right, y'all, I'm trying to get us back to where
I came up with $30,000, and there was a slight pushback, and I quite
Miss Williams' employment status at that time.
Just the answer in the question. It's the definition.
It is a.
All right, let me get us back to where we was. Okay, we were past that.
At the time that the divorce decree was filed, February 22nd of 2024, where were your children that you had joint physical custody of? Where were they living at the time the divorce was filed?
at my home.
No objection to the line of questioning that it's irrelevant, Your Honor. We've been here, we've done a whole hearing on this multiple times.
Ms. Ferry.
Well, Judge, Ms. Williams testified on direct examination a lot about what occurred during the divorce filing and being locked out and the children there and her child there and she paying child support. So
vaguely,
okay, well, let me just ask it. Let me just ask it this way. What's your response to her saying that you kicked her out, locked the door, and locked her out 3 times from the marital residence? What's your response to that?
My response is she brought an armed individual that she called a security guard to the home, and that scared the living daylights out of me. And I had to call the police about that. This was no part of our normal security details. There was no announcement that she was coming. I would have gladly let her come into the home to pick whatever she wanted. But when you bring a 350-pound individual who is armed and without prior communication, it warranted me to call the police.
All right, and ultimately, is it correct
May I expand slightly on that?
I think I've heard enough on it. I just because I allowed Ms. Williams to testify on it doesn't mean I found it to move my needle on this case at all. So I've heard enough on that. Go ahead.
That helps. That helps with the direction. Okay. So I want to turn to the prenuptial agreement, Mr. Guabadia. And I want to ask you further questions about that. So on the prenuptial agreement, I'm just gonna share my screen. Or I'll just ask you for the sake of time, and if I need to reference the prenup, I'll ask you about it. On page 32 of the prenuptial agreement, it lists that your business interest was with 𝐬𝐮𝐬𝐜 Petroleum Limited Company, and it had a total estimated value of $307 million. Do you recall that being listed on the prenuptial agreement?
Yes.
Okay. And is it accurate that the 307 mil, excuse me, let me ask it this way. I'm sorry, I think I asked that question incorrectly. Let me start over. So on page 32 of the prenuptial agreement, it lists that you, with all of your assets, liabilities, et cetera, it lists that you have business interests of 307 million approximately. And of that amount, it indicates that 296 million of that amount.
Yeah, I just wanted to jump in there for a bit and I'm gonna let the video play. I thought, and I was, after being there so long, I was so tired. But after I went back and listened to the videos, I just feel like the judge is, somebody put it in the chat. Who put it in the chat? Let me go back and look. I'm gonna put it on the screen. Miss Sapphire. I felt the same way. After I, listened to the video, I said, I feel like the judge was like, he here illegally, he got deported. And at that point, I think the judge just really didn't care. And it seemed like some of y'all are starting to pick up on the same thing. Not saying he couldn't have enforced the prenup, but the issue was he enforced the prenup, but then said he was not going to make Porsha pretty much abide by it. So I'm just like, this doesn't make sense. And even Simon's attorney was like, well, wait a minute. So I'm going to just let the video play. Just wanted to jump in there and say that.
Is attributed to 𝐶𝐬𝐵 Petroleum Limited Company. Is that correct?
That's correct.
Okay. So would you say that 𝐶𝐬𝐵 Petroleum Limited Company served as majority of your income?
Yes.
And was that also indicated in the prenuptial agreement that 𝐶𝐬𝐵 Petroleum served as majority of your income?
Yes.
Has your net worth, as far as the approximate valuation of 𝐶𝐬𝐵 Petroleum, changed since you signed the prenup November 17th of 2022?
Yes.
How so?
The revenue of which the calculation is based on has dropped significantly.
And what do you attribute that drop or reduction to?
A number of factors. I would say the majority of it is a change in our industry in the last 10 years. Most of our customers have gone away from smaller jobbers or distributors like ourselves, and have gone to much bigger companies that have a whole lot more resources to service their needs.
Are you generating any, well, let me go back. You mentioned that it's several factors, and thank you for explaining that. Are there any other factors that have contributed to the reduction in the income you're able to pull with 𝐶𝐬𝐵 Petroleum?
On February 19th, when I was intercepted on my way into the United States and taken into custody by ICE, I've not been able to operate any of my businesses.
Okay.
We had to cease operation.
So what income are you generating from 𝐶𝐬𝐵 Petroleum?
Zero.
And is that by choice? In other words, are you intentionally not generating any income through 𝐶𝐬𝐵 Petroleum?
Absolutely not.
How are you sustaining yourself?
Savings?
How are you sustaining yourself? I understand you were detained February 19th of 2025. How have you been, here we go. Can you hear me?
Yes.
Okay. How have you been able to try to sustain yourself since you've lost that major source of income or revenue?
Well, fortunately or unfortunately, depends on how you look at it, I have been in ICE custody for 109 days with no access to my devices, no access to my customers, no access to absolutely nothing. And so I was released on June the 6th, which was this past Friday. And obviously, none of my businesses have operated.
And did you arrive to Nigeria on Saturday, June 7th of this year?
Yes, I did.
Okay. Did you foresee that your income and net worth would drastically reduce the way that it has?
Absolutely not.
I want to show you the prenuptial agreement, and while I'm pulling that up, I'll ask you, is there a provision in your prenuptial agreement that indicates that you and Ms. Williams had always considered you to be the higher net worth earner?
That's correct.
I want to show you what's already been entered into evidence as Respondent's Exhibit 13. Okay.
I'm gonna object. They updated the financial affidavit for me to now have to cross-examine. You're gonna update it, and it's that drastic. He's been out of custody for a while. He's saying this happened for a while. To now come in and blindside us at the end of the day and say my income has changed and here's what it is. When I asked him, he didn't know, and now at the end of the day,
It's fair.
No, he answered it on direct examination, which is why I'm exploring it, because I think Mr. Kessler asked him, was his income higher or lower? And quite frankly, Judge, I mean, he can get into all the reasons why we've had some issues with being able to get certain documents and prepare for today. He can testify to that, but at the end of the day, the same thing that he would put on the updated financial affidavit and swear to under oath is the same thing that he would say here today. It doesn't make a difference one way or the other. He can regurgitate it on paper, or he can testify to the court. Either way is evidence, and he can certainly cross-examine him to his testimony.
but that's the reason they're required to give it for trial, so that we can see what it is, instead of being blindsided. We did the discovery, we did it.
I'm going to uphold the objection. I mean, there's no updated DERFA. I'm upholding the objection.
The objection to what, Judge? I'm sorry, because he testified to this earlier. Like, he testified earlier during the cross-examination of Mr. Kessler. We can look at the transcript. He specifically asked a similar question, like, what do you mean it changed for the $253,632? Is it higher or lower? And I believe he answered that it was lower. So that's already in the record, Judge. I was gonna have him expound on that.
But he said he doesn't know. I asked him what it was. He said he doesn't know.
I wrote it down. You can roll the tape back. I wrote it down.
All right, Shauna, can you take a look at it?
Yeah, I'm gonna need a few minutes to find it.
Okay, I know.
It was only 5 hours ago.
Yeah, well, no, he said
while
he didn't
she's
know.
looking, I mean, while she's looking, I am going to tell you that it's my prerogative. I'm only going to allow very brief closings. Based on pace and based on this going way longer than I anticipated it would, y'all, I could probably do each of your closings for you. So it's going to be very, very brief closings.
You're probably doing better than me. That's better.
Well, Judge, I mean, the testimony from Mr. Guabadia was he didn't know the exact number today of what he made, but the question from Mr. Kessler was it higher or lower than the 253? And he said it was lower. That was the testimony, but I'll let Ms. Myers look at it.
But whatever it was, there should have been an updated DERFA if it's much different.
Well, I didn't get updated financials either from Ms. Williams, but I mean, I didn't even get a notarized DERFA.
Right, and she didn't try to testify to what her new income is or old income is, so that's why we didn't do it.
I guess, I mean, we'll mention that in closing on share, because I think, anyway, well, I'll argue that in closing.
What are you saying, you have 15 minutes each? Can we promise the judge that? What do you want to do?
I don't know.
It'll be my decision. But sometimes I say no closing. And so depending on how much longer this goes, I may say no closing. So I'm just giving you a heads up. It needs to be tight.
Hey, Judge, is there any way we could just go off the record? Because all the talking is distracting my reading.
I'm sorry. Yeah, we're off the record. I'm going to take a brief break.
I'm sorry. I thought we were off the record. I didn't mean to keep you busy. This court report.
You had listed there was $253,632 per month at the time back in August of 2024. Just so it's clear.
But Your Honor, I'm going to renew the objection if it's comparing to the financial affidavit. The Superior Court rule states clearly the parties have a continuing duty to supplement documents described in this rule, including the financial affidavit, whenever material change in the financial status occurs. Any documents produced under this rule or served on the opposing party less than 24 hours before hearing or trial are in violation of the court scheduling order and shall not be admissible into evidence at the trial unless the court finds good cause. So if it's changed, they needed to submit a new DRFA.
I hear you, and you made the objection.
Okay.
But you asked on cross, and do you make less? And he said yes. So based on that, I'm allowing it to go forward. So go ahead.
Okay. Mr. Guabadia, can you afford to pay the $40,000 per month under the prenuptial agreement based on your circumstances today?
No.
Can you afford to make the payments to the marital residence or the carrying costs as it was defined in the prenuptial agreement of approximately $50,000 based on your testimony? Are you able to pay that today?
No.
Are you able to pay the other costs and expenses under the prenuptial agreement terms? And when I say other, for example, the attorney's fees that's being requested of, I believe, over $200,000. Can you afford to pay Ms. Williams' attorney's fees?
Certainly not.
Objection again, Your Honor. The ability to pay is not relevant to attorney's fees. It's 100% of anyone who opposes the prenuptial agreement.
Go ahead with your response. I'm not the attorney here. Go ahead with your response, Ms. Ferry.
I was gonna say, Judge, I mean, it's kind of like twofold because we are here for a final as well, and the court has not made a ruling on the enforcement. Not only that, I think it goes again to the change in his financial circumstances and explaining not necessarily what Mr. Kessler thinks I'm getting at, is more so surrounded the change in his financial status and circumstances as it relates to the terms. One of the things that Blige versus Blige, a Supreme Court decision, requires this court to consider is the fundamental fairness, of the terms of the
that's what I was thinking when I overruled Mr. Kessler's objection. I don't necessarily buy it, but I know that's the argument that you're making, that there's been a material change in circumstance that would be unfair to him. So keep rolling with the question on the attorney's fees.
Okay, I keep wanting to say Mr. Kessler, I think because I'm talking so much with Mr. Kessler. Mr. Guabadia, as far as the attorney's fees that is being requested of you pursuant to the terms of the prenuptial agreement, are you able to financially afford to pay $224,000?
Okay, I just want to address a question just so y'all can understand. So somebody said, did he lie to her and say, where did that go? That he can pay her $40,000 a month. So I don't know if you saw the previous videos. He actually paid her $30,000 before they got married. So he actually had already been paying her, and then into the marriage he was paying her. So he was showing that he could pay it because he had already paid it. Just want to throw that out there. And thanks for the super chat. This cat rocks. I really appreciate you.
$1,000 or 200 plus, et cetera, attorney's fees to Ms. Williams?
No.
Have you been able to pay attorney's fees to any attorney, including myself, since you've been detained in February?
No.
There is a provision in the prenuptial agreement that relates to confidentiality. Are you familiar with that provision?
Yes.
Why was it important to you to have this confidentiality provision in the prenup?
Primarily because I'm a parent to 3 young children of school age that I have co-parenting agreements with, and I'm sort of other co-parents. And it's important to me to provide the protection that they need, and to provide, continue to not just feed them, but ensure their safety. And as the court, as we all know, when you have parents who are some type of public figure, there's a tremendous attraction from the public, and this was the only way I could see to protect my children.
So did you bargain this benefit when you were negotiating what you would pay under the prenuptial agreement to Ms. Williams?
Absolutely.
If this prenuptial agreement is enforced, if this prenuptial agreement is enforced, what benefit do you gain from your bargain?
No.
Is it your contention that Ms. Williams violated the terms of the confidentiality provisions of the prenuptial agreement?
From the very first day it was announced that that she was filing for divorce on February 22nd, the third day, the very next day, all the blogs had identical references about the filing.
How did you learn that a divorce had been filed against you?
Well, she called me the night before when I was in Costa Rica to let me know she had filed for divorce, and she wanted to let me know. And prior to that, I had no reason to believe that we had any reason to file for divorce. And I said, I'm on my way back from Costa Rica. I will discuss it when we got home. And on a 3-hour flight to Costa Rica, all I heard from my phone were multiple text messages indicating that the blogs, People Magazine, all the major outlets had picked up on the fact that she had filed for divorce.
And so when I asked you about you believe in whether she had violated the confidentiality provisions, you said yes very early on. Was there anything else that she did after she filed for divorce that believes you or leads you to believe that she violated the provisions of the confidentiality that relates to?
No, I want to have a standing, ongoing objection. I probably do, but again, this is not a motion for contempt of the prenup. The questioning is, she's violating a document that you don't want to be enforced, and so I object to a lot of questioning. And instead of objecting every time, because I assume she's near the end, I'd just like it to be a standing objection to this whole line of questioning.
Well, I'm going to overrule it, although I did address it earlier, the relevance. I felt like Ms. Ferry gave some relevance to it. She does. I know that her ultimate argument is going to be in closing that they sort of an extra prong or what have you, that from an equitable standpoint, I shouldn't allow the contract to go forward. So I'm going to allow her to continue with it until the point it gets cumulative. So go ahead, Ms. Ferry.
Okay, so Mr. Guabadia, as far as the confidentiality provisions that are contained in the prenup, the question I asked you is, why did you believe that Ms. Williams had violated those provisions? And so my follow-up was, is there anything else besides you finding out from the blogs that led you to believe that she has been in violation and continuously violating the confidentiality provisions?
Most of it came from court filings, actually, about it was suggested that I was fleeing the country to Dubai. I had not been charged. I had no immigration issues for 35 years, and I had businesses. I have children. I have community ties, and not only was it filed in a public setting, but was also widely distributed. And the other major one was the fact that the one we're talking about, which is my net worth of $300 million. Not only am I a private entity, meaning I'm not a publicly traded company, and so those numbers were not for public purview, and certainly we made sure that we covered that under the confidentiality clause when we made available our financial declarations, if you will. And so not only was it made public, but also put me and my family in danger.
Okay. And so earlier you also were here in the courtroom and heard her testimony and saw what was presented during cross-examination. I wanted to ask you about that. Do you also have any concerns with regards to what she has filmed on Real Housewives of Atlanta as of last year, or last year and this year, I guess, for the season? Do you have concerns about that violating the prenuptial agreement as well?
Absolutely. If I was just, I haven't seen the show itself, but the trailer.
Then I'm going to object.
With counsel.
Wait, what's the objection? What's the objection, Mr. Kessler?
It was hearsay. When he said he hasn't seen it himself, I assumed he was going to say, but I've heard. So
I think he's referencing the trailer.
Yes, that's why I stopped.
Okay, all right, well.
The trailer is the only thing that makes reference to me that I know definitively that it violates the confidentiality clause of the prenup agreement.
And also I wanted to also ask you about Mrs. Williams partaking in what I asked her about during cross-examination, which was the interviews on TV, radio shows, podcasts, etc. Do you have concerns about her participation in that as it relates to the confidentiality provisions and what she has stated?
Absolutely, especially in light of the fact that I was not in a position to defend myself, and I was in detention for a good 109 days, and I couldn't have responded to it, which I normally would have on social media to counter every narrative that she's put forth thus far.
There was testimony by her that last year, and I'm referencing last year because to your understanding, she was recording on Real Housewives of Atlanta in 2024, correct?
Correct.
Okay. And so there was testimony by her that when she made her appearances, whether it was this year or last year, and what she discussed, she indicated or implied that she was just responding to you in what was put out in the public domain. So I want to ask you about that. To your knowledge, who was the first individual to breach the confidentiality provision as it related to discussing the divorce or your personal matters or disclosing any of that information? Was it you or her?
It was her, and to be very specific, there was a court filing, I guess part of their motion for something I can't recall, but essentially indicated that I'd flee the country and I'd flee to Dubai, and there was no reasonable chance of me coming back in light of my immigration issues, which obviously they know very, very little about.
And also, as it related to, you heard her testimony that she had filmed with her attorneys. I think she mentioned May, June, or July of last year, and to discuss the divorce, etc. Did you also learn about that circumstance last year as far as her breaching the confidentiality provisions?
Yes.
Have you provided any written consent to film or record in your home since you all have filed this divorce action?
No.
Have you, since you've been married to Ms. Williams, have you filmed or recorded on TV in your marital residence since y'all have been married?
No.
There was testimony earlier that Ms. Williams indicates she had paid child support
Child
on
support
your
issue
behalf.
didn't move me at all, if you want to move on from that. That didn't.
Thank you.
I almost stopped it for relevance, but go ahead.
Okay, the other question I'll ask you, Mr. Guabadia, is there was testimony from Ms. Williams indicating that you didn't pay certain expenses to the marital residence. What is your response to that as far as her allegations that there were certain expenses you didn't pay to the marital resident or pay for the marital residence?
All expenses relating to that home, I have paid by myself from when I closed on the home in November of 2021 to February 19th when I was detained by ICE.
And the payments that you were also paying to the marital residence, even during the pendency of this action, were you making those payments in accordance with the temporary order that was requiring you to pay it before you got detained by ICE?
Yes, I was.
One moment, Your Honor, I just want to double check my notes before I conclude. Okay, I have no further questions for Mr. Guabadia.
Okay, I will buzz through it, Your Honor, if I may.
Yeah, I mean, because it always puts me in a weird spot, you know, when you call up the somebody on cross early. So it's almost like a rebuttal situation, I guess, now. But I mean,
Yeah.
you need to be respectful of what you've already asked on cross. We're not talking about two bites at the apple here, Mr. Keysha.
Right.
But,
I'll try to go just to what she said in her direct that I need to respond to.
okay.
All right. Number one, you talked about the episode of The Real Housewives, how she filmed that. The divorce was February 2024, filed then, correct?
Mr. Kessler, you have to repeat your question.
The divorce was filed in February of 2024, correct?
That's correct.
The episode on The Real Housewives, the first episode of the season, aired March 9th of this year, 2025, correct? More than a year after the divorce was filed.
I wouldn't know that. I was in ICE custody.
Okay, but you didn't see it before March of 2025, did you?
What did I not see, Mr. Kessler? Could you repeat your question, please?
Yeah. The divorce was filed in February of 2024. You just testified that she beat you to the punch and she went out there and talked about it. And one of the examples was meeting with her lawyers. That episode did not air. You didn't see that episode until after you got out of ICE, right?
No, I saw it before.
You saw a trailer or you didn't see the episode?
I saw a trailer. I've never seen an episode.
But it was in 2025, correct?
I believe it might have been.
Okay.
I'm sorry, I don't recall.
I'll move on. It wasn't right around when it was filed. That's my point. You've given documents to the press or had people on your behalf make statements to the press, correct?
I would answer that question by saying that any documents requested by press was already public information as in court filings.
Okay. When did you leave the country? In other words, the divorce was filed, and then I know you left the country sometime within the first month or two. Do you remember when you left the country?
Mr. Kessler, I travel constantly on business, and there was no one specific time that I made a conscious decision to move out of the United States.
I'll make it. What percentage of the time were you out of the United States in 2024?
Objection relevance.
He said he can't do his business because he was detained, because he's now not allowed to come to the country. That was in our opening.
I figured that's where he was going. I'm going to overrule the objection. Go ahead.
Were you out of the country for more than half the year 2024, Mr. Guabadia?
Yes, I was.
Okay, thank you. And you still ran your businesses while you were traveling out of the country, correct?
I absolutely did.
Okay. And you agree that you violated the prenuptial agreement by not vacating the marital home within 30 days, according to page 16, correct?
I would not respond to that as in I don't know.
Okay. On page 16, you are.
Okay, well, let's move on from that one. I don't find that overly the big scheme of things.
No, it's just that they're saying she violated the prenup, so okay. There are 3 years of back taxes, right? You just said you paid all the expenses. Aren't there 3 years of back taxes due related to the home?
I wouldn't know. I believe you brought that to my attention. And if you're referring to the property tax, that usually comes in the mail. And if I was traveling or I was not living at the home at the time, it is easy to overlook.
I got you. The day after the wedding, she gave you $100,000, right?
Yes. She loaned. It's not something I asked for. She chose to, after spending, I guess, $2.5 million, she must have felt it would be a nice thing to defray that expense by giving $100,000.
Was it a loan? So she loaned it to you, or she gave it to you?
I don't recall at this time how she prefaced it, but I do recall her calling her accountant and surprising me with $100,000. I never asked for for any.
And you never gave it back to her, correct?
No, I never gave it back to her because it was not.
Okay, quick question, because I just saw a comment that I wanted to respond to. So somebody said, hold up, if you have a mortgage, doesn't the bank pay your taxes? Absolutely not. So you can have your taxes to be escrowed. What that means is you would pay your mortgage and then you pay your taxes monthly to the mortgage company. What the mortgage company does is they hold it and they pay it for you. Now, everybody don't want to escrow, because if you escrow, it's included in your payment. So some people just like to pay their mortgage and then put up their own money every month and then just pay the taxes at the the end of the year. I just wanted to respond to that quick question.
Not purpose, that's a law.
Okay. You say you were nervous about the home and didn't want her filming in the home. You've actually posted pictures of yourself in the home on Instagram to your 1 million followers, correct?
Yes, I have.
Okay. Multiple times, correct?
Yes, I have.
You say you can't afford the terms of the prenup. If you get your half of the marital home, that would be more than enough to pay the amounts due under the prenuptial agreement, wouldn't it?
I have no idea, Mr. Keys'Co.
Okay. You say your income is lower. You've not provided one document to this court showing your current income or net worth, have you?
No, I haven't, but I'm happy to.
I understand. And you've not provided one witness other than yourself to verify that your financial situation is worse today than it was at the time you signed the prenuptial agreement, have you?
No, I have not, but I'm happy to.
Okay. No further questions, Your Honor.
Ms. Ferry, I guess I'm lost here, but redirect if you have any.
Mr. Guabadia, I want to ask you, at the time last year that you were traveling in and out of the United States and running your 𝐶𝐭 petroleum business, during that period of time, you had not been removed or deported by ICE. Is that correct?
That's correct. I've been a legal permanent resident for 35 years and operated legal entities in the United States. The removal prohibits me not only from my presence in the United States, but also prohibits me from running any entity in its current form.
I'm going to object, Your Honor. There's been we've asked for the documents. He's got the ability to provide the document that shows the terms of his deportation or his incarceration or his whatever it was. He's provided nothing, and now he's testifying to what the terms of those orders are. It's improper, Your Honor. We've asked for it.
I have not received any request for these documents by subpoena, by request for production. I've done nothing. To send an email to the immigration lawyer and CC me on it is not a formal request for me to be able to legally respond to that. So
I'm not going to overrule the objection. I'll give it the weight it deserves.
Mr. Guabadia, I'll just plainly ask you, do you need to physically be able to come back to the United States to operate and run your 𝐶𝐭 petroleum business?
Absolutely.
And then as far as there was questions about you bringing any other witnesses to testify in regards to your loss of income or inability to make money with 𝐶𝐭 petroleum. How many owners are there of 𝐶𝐭 petroleum?
Just me.
And are you the individual that handles the finances and accounting or money?
Okay, guys, I want to address this because you guys are like narrowing, in on everything I said. There was no evidence. Nobody presented anything. It's like, Porsha said these were her expenses. Simon said that he lost income. And I don't know if maybe Simon just didn't have time, because if y'all recall, he was released just right before the hearing, but nobody presented any evidence. It was just, and that's why I was like, what the heck is really going on? So nothing was skipped. The only thing they presented was the prenup. Like, nobody presented anything of evidence. If y'all recall, in Porsha's testimony, she said the mortgage and expenses was between 18 and 20. Simon testifies is 50. So how is Porsha paying a mortgage if she doesn't even know how much it actually costs?
As it relates to Simcoe Petroleum?
Mostly.
Okay. All right, no further questions, Your Honor.
That's all. I'm ready for a short closing, if Your Honor will permit me.
We will do, and it was really a question of no closing or 15-minute closing, so we will do 15-minute closings.
Thank you. We'll defer and follow Ms. Ferry.
And Judge, what I'll do is I'll just
Okay, so somebody else put a good question in there, and I'm gonna put that up there. So how did they even divorce without expense sheets? Let me just tell you why. Because they had a prenup. So the prenup is supposed to prevent you from going to the judge, having the judge to kind of divide expenses. So the reason why they are in court now is because Porsha wants the prenup to be enforced, and Simon is saying, oh no, don't enforce the prenup. So if they had just divorced, they would just go by the prenup. Because keep in mind, when they got married, they did the prenup because if they were to divorce, they wouldn't have to go to court. But the reason that they're in court now is because Porsha says enforce it. The judge ruled to enforce it, but Simon wanted to pretty much have a trial and present evidence. But I'm going to be honest, that is what is missing, the evidence. I think in Simon's case, he originally said he made 300 and something million, but what they were saying was, okay, where's the documentation that shows that you no longer make this money? So in all honesty, from what I saw, it seems like Simon needed to prove that he did not have the income that he had when he signed the prenup. But y'all let me know what y'all think in the comments.
I won't really belabor the points that I've already included in my amended response, because a lot of my argument is detailed there. But one of the things that I just wanted to emphasize to the court is that when it comes, at the end of the day, the prenuptial agreement is a contract. And when it comes to a contract, there still has to be basic considerations taken under advisement by the court. So prenuptial agreements are contracts subject to contract law and principles. The issues of contract construction and enforceability are before the court. And when it comes to determining whether or not there is a formation of a contract, essentially the contract must meet the usual requirements of offer, acceptance, consideration. There's implied, sometimes expressed consent, and it also has to have the requirement of fundamental fairness. And that was stated under Blige v. Blige. That citation is 283, Georgia 65. It's a 2008 Supreme Court decision. And that decision related to prenuptial agreements. The reason I just bring that up, or let me read one other quote. Also, the implied covenant of good faith and fair dealing also attaches to every contract and requires a party in a contractual relationship to refrain from arbitrary or unreasonable conduct, which has the effect of preventing the other party to the contract from receiving the fruits of the bargain. And that citation is Miller versus Fiberlight LLC, 343 Georgia App 593 to 2017. In addition to my arguments under the share factors that I don't believe has been met, and I'll just summarize that shortly. The main thing that has been of certainly concern to Mr. Guabadia is the fact that we have a contract, and I understand the whole argument about, oh, it's circular. At the end of the day, what we have is a contract that when a person is trying to enforce it, in this case, Ms. Williams, she too has to come to the court with clean hands to be able to say that she has been complying and abiding with this.
On y'all, StreamYard is just really acting a whole fool today. I'm just like, what is just glitching and everything? All right, y'all, I'm not sure what's going on with StreamYard. What is really going on here? Like, this is crazy. What the hell is happening? It's just literally glitching like
keep a little control over.
Goodness. We almost done with this thing.
Confidentiality provisions. And so the fact that she even has signed up or signed her contract with Truly Original, which her entertainment attorney and even the Truly Original executive
and shout out to Nola for the super chat. Thank you so much.
Producer or professional, I forget what her title was. But when Ms. Williams attached their affidavits to her motion, they even indicated that she has to be able to film in the marital residence. And so the fact that she's even entering into these contractual agreements that is essentially violating the confidentiality provisions certainly should not, she shouldn't benefit from that. The financial information that I submitted to the court, I believe it was the balance sheet as of June of 2024. Looking at that balance sheet, when considering Ms. Williams' financial net worth, it indicates that she has a business interest of over $9 million. And certainly that's a huge difference from and that $9 million on the balance sheet was just for one company, the 𝐟𝐨𝐿 LLC, which is a huge difference from her. She put a net worth of $3 million overall with all of her interests. But just from this one company, her net worth or her equity interest, as shown, is $9 million. And so I asked her, was the 𝐟𝐨𝐿 the business where she gets paid from the reality TV show and live streaming and all of that? And she mentioned, yes, that's where that money goes. And so when looking at that, the fact that she is benefiting to the tune of having an equitable interest of $9 million as of last June of 2024, and that was just halfway through the year. And she mentioned during her testimony, she has to talk about her personal life. You know, she talks about her personal life. She has to film the day-to-day activities. She has this lucrative contract that also, by her testimony, she believes pays her $80,000 per episode, guaranteed 10 episodes. So she has all these financial gains and benefits from violating the contractual provision.
Okay, this is why I really love y'all, because y'all be really picking up on stuff that I be saying, okay? But make sure y'all hitting and liking the video. So there is a message in the chat. I'm gonna try to put it on the screen. I really hate touching this because every time I touch it, it glitches. And I'm not sure what's going on with stupid old StreamYard. But did y'all hear her say she told him if he fly, he will get deported? Then he is deported. That backstabbing garden tool, she will get. So that is exactly what I noticed when I was listening to this. She suddenly tells him, don't fly because you will get deported. And then he is deported after going to the airport. Y'all be on it.
And then what she wants the court to do is turn around and then say, well, still enforce the provisions, even though I'm violating it and making all this money, still enforce it so that way I can make additional monies under this contract. It's just not fair. The fundamental of fairness is not there. And I think the court did pose a great question of, you know, it's like, where do we go from there? The contract indicates it was important for both parties to have that confidentiality provision. They both agreed that there will be irreparable harm suffered. And that's exactly what has occurred here. And so the court does have the discretion under contract law and Georgia law, and there's case law that I cited to in my brief. The court does have a discretion based on that to not find that the contract is enforceable when there's been a party or parties who are just not complying with the terms of the contract and don't intend for there to no longer be a contract because their conduct says otherwise. I would say that it would need to be invalidated as a whole, period. Otherwise, Mr. Guabadia certainly doesn't get the benefit of his bargain. Now, let's say Your Honor does not enforce the contract. Essentially, what that would mean is Ms. Williams doesn't completely lose out. That just means we go the normal divorce track, and then she can make her argument as to what she believes is an equitable division of property when it comes to the marital assets. She can argue what she believes is equitable division from any businesses, any real estate, any financial accounts. So she doesn't lose out completely. But the only person who loses out completely is Mr. Guabadia, based on the actions and the conduct. And so I just wanted to argue that and tie that together. That's why I was asking questions about the conduct, because that's something the court can consider when determining the formation of the contract, the enforceability of it, whether the parties have veered from it. And to the extent that there's going to be argument that, oh, well, we could strike one part and not the other, again, it goes hand in hand. Mr. Guabadia bargained to pay her certain monies in exchange for privacy and protection, something that he has not gotten. I don't believe that there has been, I don't believe based on the evidence that the petitioner, Ms. Williams, has met her burden of proof. Going through the prongs, as far as the change, I'll start with the third prong, showing that there's been a change in circumstances. There's certainly been a change in circumstances with regards to her. Her burden of proof should be that there was no change in circumstances that were rendered the contract unfair. I've proven just the opposite, even though I didn't have to prove that. I've proven just the opposite when it comes to her financial situation, it being $9 million.
I have no idea what's going on with this damn StreamYard. It's literally doing its own thing.
You know, just trying to keep
Crazy.
You say you can't afford the.
So enforce it so that way I can make a increase. Right now, as we sit here today, based on the evidence and testimony that's been presented to this court, she's earning more than he is.
They did. They pushed back. You know, he says things to the press. He posts things. He says, when I asked him, did you release anything? He says, just what buy a home. He testified to that. As far as, you know, not understanding the prenuptial agreement,
okay, I gotta go.
That there was a significant change. Prenup means you don't enforce it.
Addressing discovery and whether or not the court would compel Ms. Williams to respond or produce certain discovery. That was the context of him providing his testimony. To talk about the enforceability as a whole, I think his testimony certainly lacked and fell short there. So I would argue that the court should give very little weight to his testimony. So we would ask that the court not enforce the prenup and that we proceed on a regular divorce track. And the court can shorten the divorce track certainly and limit it based on its discretion, but we believe that would be fair.
Okay, Mr. Kessler.
Yes, Your Honor. Couldn't pick a better attorney to draft a prenuptial agreement. Couldn't have longer period of time to negotiate it. The reason you do prenuptial agreements with good lawyers that are not cheap is to not go through all of this. He talks about privacy. They're creating, like Your Honor has mentioned, a fourth prong. It's a red herring, Your Honor. He's not concerned with privacy. He did an entire TV show with her. He just said he posts to his more than 1 million followers on Instagram from inside the house. There's no security concern. He also is complaining about her violating the agreement when he clearly himself is the one violating it in a much bigger way by changing the locks on the doors, not vacating. Prenuptial agreement says he vacates within 30 days of a divorce being filed. His first lawyer that drafted the prenup wrote us and said he's going to vacate, asked for an extension. Then he switched lawyers. He can't come in, and that's the whole concept of clean hands, and now say, oh, but she's violating the agreement. You know, it's like you push somebody, and if they push back, oh, look what they did. They pushed back. You know, he says things to the press, he posts things. He says when I asked him, did you release anything? He says, just what was in documents, meaning he released documents. Every time there's a pleading filed, oh, they filed something and it's in the press. But she's the one who's out there. Your Honor heard the clips that they put in. Your Honor didn't even see the first clip of the Real Housewives. Had Your Honor seen that, you would have seen she didn't do anything bad, and she was nice about him, said nothing negative about him except taking the high road. Your Honor, they didn't quote any prenuptial cases. They're trying to come up with new law, citing other law for other cases. And there's no prenup case that says violating prenup means you don't enforce it. That's a circular argument. You enforce it, and then you claim that someone violated it, and you file a contempt or a breach or whatever you want. And again, he would have unclean hands because he clearly not only didn't vacate, he didn't let her move in. He changed the locks 3 times. She incurred cost. And his excuse, his explanation, oh, she came to the house with a security guard. And if Your Honor listened carefully, he didn't say, I would have let her move in, but she came with a security guard. He said, I was letting her come get some stuff. He had no intention of complying with this prenuptial agreement. His testimony was clear. He doesn't want her to have that house. He regrets he ever signed that. He's mad about it. He couldn't, that was clear. He was truthful, he was honest. That's the only time that I think the credibility was in his favor, was that he said, yes, I don't want her to have that house. That's why I'm fighting this. 2 words he uses. His lawyer says he's not a public figure. All this stuff's hurting him. And then we show, oh, his Instagram identification, first 2 words, public figure. Doesn't have any idea what his net worth is. He's got the burden, as Mr. Bates said, and as Your Honor knows, someone challenging the agreement, saying that there's been a change of circumstances, has to prove there's been a change of circumstances. He has no idea what his net worth is. He still didn't testify what his net worth is, and he had the ability to bring documents, to bring witnesses, to bring managers, CPAs, forensic accountants. He had the ability and money to bring a expert witness to talk about entertainment contracts, but not to bring one to talk about his financials. Forensic accountants appear before Your Honor all the time. They could have had one come in to make it clear that there was a significant change in financial circumstances of either side. They didn't do that. As for being out of the country, not being able to run the business, his credibility, Your Honor. He was I was out of the country more than half the year. He ran his business just fine. Oh, because of ICE, I don't have a company anymore. Well, he fired all his employees in November of 2024. It had nothing to do with ICE. He had no reason to believe that ICE would keep him or take him. Yet the order on January 11, 2024, that initiated our client's concern about the marriage is clear, and it's in evidence. That order, and it goes to his credibility, and it goes to the veracity of his statements that he didn't know when he came back he would be taken, says clearly he misrepresented his marital status. He improperly answered no to the question of whether he had any prior arrests or convictions, incorrectly answered no to the question about whether there was any factual basis that made his inadmissible under 8 U.S.C. 1182, given his criminal history, and he misstated the date of his last entry into the United States. That's a finding of fact that's relevant and admitted, and it's a finding of fact by the United States District Court.
I'm going to object to arguing facts not in evidence, Judge. That did not come into evidence.
I thought the order went into evidence, Your Honor. In any event,
well,
he knew about that order. He knew about that order.
He's moving on from that anyway, so go ahead, Mr. Kessler.
As of August 24th, he still had 𝐶𝐭. Okay. Exhibit P31-C, Your Honor remembers the text. He loves Dubai. Dubai is his home. He considers Dubai a home. He testified to that. As far as, not understanding the prenuptial agreement, Exhibit 31-C, his post to the whole world. I think a man with a college degree and 35 years of professional and business experience can read a prenup and know what it says. But it still violated it and didn't let her move back in the house. My love affair with Dubai began at this very hotel in June 2021. Not in my wildest dreams that 3 years later, this will be my home. His words, admitted as evidence, on December 19th, 2024, not in my wildest dream that 3 years later, after June 21st, June 2021, that Dubai would be his home. Dubai was his home, not the United States. Again, as of today, he's not said anything. He's not told the court what his net worth is. He's got the burden. He tests.
Y'all have some very interesting stuff that y'all putting in the chat. Felicia Wilcox, South Florida real estate pro. Girl, that's a long name. You said Porsha's attorney is well respected and well known divorce attorney, although the judge displayed an impartial demeanor, but we all know they are golf buddies. Judge was just playing to the media. So I kind of think that, you know, the judge is still an attorney. Yeah, I was kind of thinking that as well. I just wanted to say that because it just, I don't know, this just seemed a little crazy to me.
There were also the texts between the parties that's in evidence. P6, he texted to her when she was telling him, be careful, I want you to talk to the immigration lawyer, I'm worried about this order. He wrote back, I cannot be deported. Well, he was wrong, but that's not the question. The question is, was he aware of the possibility? And certainly there was a discussion going on, a concern, at least expressed by our client, that he might be deported. He knew about that, yet he came back. So it's of his own accord that he got taken into ICE custody. And still, it's not a change of circumstances that he's now been deported because he wasn't in the country for more than half the year last year. He's been on his DERFA, which was not updated. He said, defer to my schedules on my prenuptial agreement. DERFA was filed after the divorce was filed. Prenup was signed before the marriage was entered into. Our client, as far as there's been no evidence of her income, that she has contracts for Real Housewives, as everybody knows, and the court could even take judicial notice. They're season to season. Hopefully she gets another contract, but there's been no proof whatsoever that she's got a contract that she will be earning any money as a Real Housewife next year. It's year to year. Hopefully this situation in this case didn't sour the company on her and bring too much negative light to the company and to the franchise. They value their franchise. He said the industry, he said when his lawyer asked him how's business, he said it's been declining. His words, Your Honor, 10 years. It's been declining for 10 years. That means when he signed the prenuptial agreement, it was declining. So it was certainly foreseeable. This wasn't an act of God. This wasn't something that he said, COVID put me out of business or this happened. He said, his own words, the industry's been declining for 10 years. He signed the prenup. The negotiation. Our client asked for $100,000 a month. He negotiated from 30 up to 40. It was a negotiation. Whether it's a lot of money or not a lot of money, it certainly was negotiated. It was certainly considered. The arguments about breach of confidentiality as a basis to not enforce are ludicrous, Your Honor. There's not one citation to a case related to a prenup or to a statute, and it's saying the agreement that I don't think should be enforced, she should have followed, and because she didn't follow it, it should not be enforced. I mean, that's the best way I can enunciate it. But again, it's circular logic and it doesn't make sense. We asked the Honor to enforce the prenuptial agreement. Clearly, the other thing he did not do is the agreement says within 60 days of being married, he is to transfer the title of property into a trust in joint names. That's another thing he didn't do. That gives him unclean hands. And our concern, the court has the power and the equitable powers to do this, is not that you enforce the prenup in that respect and make him go back and do it retroactively. Now Your Honor has to find a fix because he is supposed to transfer from the trust to her now, but it's not even in a trust. So why go through that step with a person who's not credible, who hasn't paid bills, who's been found to be uncredible by ICE and by the United States Northern District Court, who has lied on the witness stand, who has, in my opinion, been fully impeached. And when you impeach a witness as to one issue, Your Honor can discredit all testimony to any other issue. Clearly in the past, he's lied about his marital status, about his criminal history. He's blamed ICE. It's his fault. He knew there was a risk. He came, and now he's saying, oh, since I didn't know, I should be let off the hook because I went to ICE. And yeah, I lost my business. And there's only one witness. This big a case, this big an obligation, this big a result, and the only evidence they have to prove that his income or financial situation has changed is him just coming into court and at the end of the day saying, yeah, that business isn't here. He is an entrepreneur. He is a successful businessman. He has other businesses. He has income. He has the ability to pay this. And if he doesn't, then he can pay it out of his share of the equity in the home, the whole point of the prenup is to avoid all of this. We'd ask that Your Honor enter our order, which includes a judicial deed to transfer the property to her. She's ready to do the right thing. She's done the right thing throughout. She's paid the bills that he didn't pay. She's paid the lawn care. She's paid the utilities. She's paid his child support. She's paid the things that she should have had to pay because he was obligated to pay them under the prenup and under the temporary order. And she will take charge. She will make sure this house gets either refinanced or sold and that it gets divided the way it's supposed to be divided. She does what the contract called for, what the parties negotiated, what the parties intended, what the court should enforce. We also ask that Your Honor award, as the prenup says specifically, 100% of the fees related to the enforcement and to combat any attempts to not enforce it, including having to file for a request to get use of the house and to be in the house and to get, and all the discovery issues and all the getting back access to the house and the right to film in the house because he was sending cease and desist when she should have been in the house under the prenuptial agreement. Those fees exceed $235,000. It was $225 up until today. It's been over 10 hours of my time, Ms. Hayward-James' time, and Ms. Bierbauer's time. It certainly is closer to $250, but we're asking that Your Honor award $240,000. The agreement says that it's to be paid within 30 days, whenever the earlier of when the court orders, or within 30 days of a final judgment decree of divorce. We imagine we're going to have a collection problem. We imagine there's going to be an appeal. We ask that the court not only rule, but rule quickly, because every time the court has ruled in a way that's contrary to what Mr. Guabadia wants, there's an appeal. There's a request for reconsideration, or there's a request that the court reconsider. So she's got to move quickly. The clock is ticking. Under the prenup, she has 36 months to refinance or to do what she needs to do with it. It's now been over 12 months. She's done the right thing. Unfortunately, interest rates are higher than they were had they done this the right way in the cooperative way.
Objection, assuming facts not in evidence, Judge, about interest rates and such.
I think the court can take judicial notice that interest rates have risen in the last year, but if not, then don't take judicial notice.
I'll overrule the objection.
And with that, Your Honor, we thank the court for its time, for its staying late, and we ask that the court not only enforce it, but grant a final divorce. I don't think there are any other issues left, except that the parties have put in their pleadings that they both think the marriage is irretrievably broken, and they've met the basis for jurisdiction. And we'd ask that the court grant a final divorce and incorporate the terms of the prenup in the order that we proposed. Thank you, Your Honor.
Okay.
Just want to remind the court, so Your Honor can include this in the feedback or ruling. At the onset, I mentioned that there's the pending motion to vacate, Judge. So I don't want to say that there are no other issues. I think that's contained within this. And the request I had made earlier is that the court looks at that pending motion to vacate the order if the court is going to enforce the prenuptial agreement. So that is pending. I did raise that at the beginning in my opening.
Obviously, we oppose that then.
Okay. Okay, I'll start with the conclusion first, and then I'll give you my findings of fact and some conclusions of law. I am going to enforce the prenuptial agreement. I'm going to grant the motion to enforce. So, Mr. Kessler, I'm going to have you write this proposed order, and the reason why I say write the proposed order, I've reviewed your proposed order, but there are some changes that I plan to make regarding it. And so first, I'd like to state that as what's been said, we've been through quite a bit of testimony, especially if you're including under PACE and the testimony that was given during the discovery hearing and now the hearing today. We have really dug into this deeply. It's the issue regarding discovery was a novel issue. and an interesting one. And I'll say that both of the attorneys were very good and competent attorneys, and I will say that Ms. Ferry presented some very novel ideas and did her best as far as presenting creative arguments. But in the end, this was a very carefully negotiated prenuptial agreement, given the fact that this agreement was negotiated almost as long as the marriage. The agreement was negotiated for almost a year with very competent attorneys, and therefore there was no fraud, there was no duress. These are both competent parties. Mr. Guabadia, an accomplished business person who had hired very competent attorneys to do this. There were full disclosure of assets and liabilities, and it was not at all unreasonable. Getting to the material change in circumstances, I heard quite a bit of testimony regarding it, but I don't find there to be a material change in circumstances that's unfair to Mr. Guabadia, as I heard, his net worth of his the $300 million and $297 million of it to Simcoe Petroleum. I just don't find it credible that, especially since he testified to the fact that he was able to run the company out of the country before the ICE incident. I don't find it credible that he was unable to, and I also don't see how, even if it were true, I don't see how $297 million just disappears in the ether over a matter of months with no way to recover any of that. There was testimony. I mean, Mr. Guabadia himself testified that he had let go either all or the majority of his employees, and I feel that this was, if there has been, in fact, issues with Simcoe and harm, as was pointed out in the closing and in testimony, there were no other witnesses that came on to testify as to what Mr. Guabadia's current net worth is, where the company stands. I had questions in my mind, were there adequate higher level employees that could have taken the reins. I mean, $270 million company is quite a large and successful company. And so I didn't find that at all, regarding, and I sort of referred to it as an extra prong, and I've already referenced Ms. Ferry's creativity here. Both attorneys have tried to make equitable arguments to me, and I'll get to Mr. Kessler's a little bit later regarding the house. But regarding Ms. Ferry, she made a very valiant attempt at an equitable argument. The confidentiality was very, very important to Mr. Guabadia, and of course you can't unring the bell, and what's been done is done. And so, really the entire contract should be blown up over this. I'm not sure. I find that I went back and pondered that in my chambers at a break, and considered that some even then, and considered it even, and continue to consider it as testimony and argument was given. I'm not even sure that in of itself is a valid reason to blow up the contract. But I would say that in the end, both parties had unclean hands. I know Mr. Guabadia cited his children, how important the privacy and the confidentiality was to him, but there was testimony and evidence evidence presented that Mr. Guabadia has a large Instagram following. He was happy to make posts regarding the marriage, and of course I saw the testimony with Ms. Williams and the evidence with her podcast episode that broadcast to a very large audience. And so we ended up with an argument really about who has more unclean hands or who drew first blood. But in the end, I would say that both parties have unclean hands when it comes to the confidentiality aspect of the prenuptial agreement. Give me a second here. So, you know, we have some issues regarding the house, and I've alluded to this already, Mr. Kessler, but this was a very carefully constructed agreement, very detailed, and I'm enforcing the prenuptial as it stands, and I know you've made an equity argument that why it should be transferred to Miss Williams. I heard some testimonies, some conflicting testimonies over the expenses of the house, and I heard some testimony regarding some missed mortgage payments. And in fairness to Mr. Guabadia, I feel like those missed mortgage payments were either 2 to 3 months. I tend to think it was 3 months, but that is the time that Mr. Guabadia was in an ICE detention center. And so I know there's concerns about Mr. Guabadia now not being in the United States and having few assets, and I get the inference as far as being able to attach judgments, but I do believe that a lot of that is speculative over what can happen in the future. I didn't see enough evidence regarding abuses on that front to try to buy into the equitable argument that I'm going to go in and change what I think is a very valid prenuptial agreement or partially enforce the prenuptial agreement. And so I'm going to let that stand the way exactly how it's written. You know, there is an issue there.
May I ask what that means, Your Honor? I'm sorry to interrupt, but as I understand the prenup, he was supposed to transfer to a trust.
Well, I'm going to get to that, Mr. Kessler, and then what I'm going to do is once I'm done, I'll offer questions for both sides regarding my ruling and how that relates to the order. You know, as I was saying earlier, regarding the confidentiality, Ms. Ferry had tried to make an argument it was irreparable harm. It was hard for me to buy that argument given his Instagram presence and his large following and some of the posts that he made. But getting back to the house aspect, yeah, that is an issue that it should have already been, that property should have been transferred into a trust where they are 50-50 owners, and that has not happened. That was honestly that was an issue that I contemplated for buying into this equitable and just transferring the entire house, but I still don't think it opens the door to a very well written and there was substantial amount of language in it regarding the sale of the house, and so Mr. Kessler, I'll tell you what, we'll address your question, but I do think that needs to be addressed in some manner as soon as possible, how Miss Williams is going to get her current 50% ownership of the house in a trust while all this is going on. And again, we can address this after I'm done with everything else. Apparently there's back taxes on it. I mean, those are, in my mind, they're considered liens, but you can choose in your proposed order. I don't have the wording here in the prenup, but I would assume that would come out the top anyway regarding the house and before the 50-50 is divided. That's just something that we'll have to address. We've got and the attorney's fees. That's in the that's clearly written within the prenup, and I found the law firm that represented Ms. Williams at $247,025 to be reasonable, and so those will be Mr. Guabadia, under the terms of the negotiated prenuptial agreement. Mr. Guabadia will owe that to Ms. Williams. There was a motion to vacate regarding my order, based on the filming in the house. I'm going to deny that motion to vacate. Reading into the prenuptial agreement and whatnot, I'm denying that motion.
And so, guys, that was part of it that I had originally said. The judge upholded the prenup, which is okay, but he still allowed her to film in the house. And what Simon's attorney was like, okay, that can't be like separated like that, because if you're going to uphold the prenup, then you have to go with everything that's in it. And that's what the judge is doing. But he says, well, I will not enforce the part where she can't film in the house. How do you do that? You either go with the prenup or you don't. And this is why I was saying the judge is biased, in my opinion, because he upheld the prenup, which is fine. But then he said, I'm going to uphold the prenup, but that part in the prenup that it says that Porsha can't film in the house, I'm going to let her film in the house. And I'm just like, that doesn't make any sense.
Vacate. I'll allow for questions now on my ruling, although I do think we need to roll into the divorce. I will get the opinion of the attorneys whether we at least need to do some statutory questions regarding this, or if they don't believe it's necessary. And then obviously my plan is to grant.
Oh, and just so you guys know, the judge already in a previous hearing said that she can film in the house. The only reason why Porsha is not is because the network does not want to be sued. Y'all know Bravo and the production company, they've been sued all these different times. They don't want no smoke. So the judge has previously ruled that she can film in the house. I think if y'all go Google that, you'll find it. But Simon's attorney filed a motion back in December of last year. We're in the month of June and the judge never even heard the motion. So Simon's attorney was like, well, what about my motion for her filming in the house? And if y'all go back and watch, I think it was the other video that I did a few days ago, what Simon's attorney said, if you decide to enforce the prenup, then that means you cannot allow her to film in the home, because if you allow her to film in the home, that goes against the prenup. And shout out to Chatty Chairwoman. Thank you for the super chat.
The divorce based on irreconcilable differences and incorporate this the final prenuptial agreement into the divorce. But Mr. Kessler, I'll start with you since I've charged you with, making adjustments to your order. What are your questions?
Thank you, Your Honor. The main question I have is, how do we let it do what it's supposed to do? How do we let our client, how do we let Miss Williams refinance it? The first step is to have it placed into a trust, and who pays for the trust, and how does he, is that all on him? Because he didn't do it, I would think that would be his responsibility to do it expeditiously. And I would also suggest that if it doesn't happen, if he doesn't put it into the trust, immediately, that then the court consider the judicial deed remedy without us and keep this case open so that we don't have to serve him in Nigeria for an enforcement and contempt action. So somehow, and I'll have to think about it, and I'll have to come up with some language for consideration, and maybe Ms. Ferry and I can agree, but probably not, and we'll probably send it to Your Honor. No offense, but we just have different opinions on things.
Yes.
But I think.
Well, I can start with this, that yes, he is 100% responsible for getting it transferred in. I don't know what you mean by immediate. You can include that in your proposed order. I would think that 30 days is appropriate in my mind as far as immediate. And then if you want to propose language If that doesn't happen, you know, that's concerning, and at some point there needs to be a remedy on that, and I would consider your language at that point in the order.
And I'll have to do some research, because I don't want to have to re-serve him and have an enforcement action and have delays. I want it to be part of this action, so I'll try to think about how to make it part of this order, that he shall do that, and if it's not accomplished, then this court order shall act as a judicial deed. Maybe that's the way to do it, that the court has a judicial deed transferring ownership to her that is not effective as long as he transfers it to a trust within whatever period of time. And again, I'm thinking out loud. I don't want to be bound to this, but I'll try to come up with something that solves what I see as the court's instruction and obligation to try to bring this to a conclusion without having to then come back and say, well, hold somebody in contempt because they didn't do the thing. You know, obviously, you know, you may be hearing from us again. They may be calling Your Honor and asking for a status conference about, can you have, if they need 10 more days, we're not going to have a problem with that. The other thing I have an issue with.
Well, and I could say, if there's a status conference and he needs 10 more days, there better be, you know, evidence that there's been a motion towards this goal. But go ahead, Mr. Kessler.
The other dilemma that we have, the only other dilemma that I think we have is, is she going to be able to refinance when it's in a trust in both their names? Is it such a kind of trust? Will they only refinance the house because it's been put into her name? So we'll come up with some sort of language that says he's to.
And if y'all recall, I told y'all all of the computers shut down. So this is where it started. As you can see, the screen that I was filming, it shut down. So I moved to the other screen. So
cooperate with the refinance and sign whatever documents. It may be that in order to refinance, he has to transfer title to her so that she can refinance and then give him his half. And if that's the only way it can be done, I want to have the cover of court order for her to be able to do that.
So, and this is what happened, y'all. Keep in mind, we are in a courthouse. And at this time, it's about 7:05 or maybe around 7 something p.m. Keep in mind, those people are gone by 5 o'clock. So we sitting there, as you can see, now the systems are starting to reboot and it says no signal, but we can still hear them over another monitor. And then if y'all gonna see me move to another monitor.
I understand we're gonna try it with the trust, and she's gonna try to refinance even though it's in a joint trust.
Well, I'm gonna contemplate it all, Mr. Kessler, and I contemplated it back in my chambers, but back and forth and all this, but I sort of, you know, my final thoughts on it were you live and you die by the prenuptial agreement, and that's what was negotiated. And if your client is stuck with some issues that perhaps should have been negotiated on the front end, it would have to be fairly extraordinary for me to consider.
As a friend of mine once said, how extraordinary is $240,000, you know, to get us here?
Yeah.
You know, it's been quite a journey. So we'll craft some language and ask Your Honor to consider it, and I understand Your Honor's intention, but, you know, I know Your Honor doesn't want us back before Your Honor trying to figure out how to solve another problem. And it is a court of equity, and the court can do equity when needed. Thank goodness we're in Superior Court. The only other issue, I think, is can you grant a divorce? I'm okay not having either party say the marriage is broken beyond repair. I think we could go to the pleadings, but if Ms. Berry doesn't agree and wants one of the parties to go through the motions, I'm happy to ask my client the statutory questions or have her ask hers. In fact, to make it easier, why don't I go ahead and do that, Your Honor, just to get it out of the way?
I mean, that's fine to do that, and I'm going to give Ms. Ferry an opportunity to ask questions if she has any about my ruling, but why don't we go ahead and do that? Ms. Williams is under oath already, so Mr. Kessler, why don't you ask the questions?
What's going to get ready to happen? Because I know some of y'all was like, well, are they divorced now? So now they're going to ask her the questions that are required to grant a full divorce. And yes, they're doing a divorce now. So they are done officially.
Your statutory questions of your client.
Thank you. Ms. Williams, have you been a resident of Georgia for at least 6 months before the filing of this divorce case?
Yes.
Was your husband a resident of Georgia at the time that you filed for divorce?
Yes.
Are there any minor children of this marriage?
No.
Is your marriage broken beyond repair without any possibility of reconciliation?
Yes.
And are you asking that the court grant you a final divorce and incorporate the terms of the prenuptial agreement as part of that final judgment decree of divorce?
Yes, please, yes.
I think that's all the questions, unless I missed one, Your Honor.
I think that's all of them. So Ms. Ferry, do you have any questions about my ruling?
So I was trying to find the provision that talked about the trust so I could think through some because I was being very optimistic today. So I will admit I didn't give a whole lot of thought to how matters could happen as far as any transfers and such. I just know that just based on, the case law, and the court knows that the court can't rewrite the contract, but, and I think any contempt, so the case law that I found indicated that if there was any type of judicial deed, it was more so done in the context of a contempt. So if someone didn't comply with whatever, court order there is or provision or what have you, then there would be a contempt, and then the remedy there would be the judicial deed, and the judicial deed would be issued to carry out the terms of whatever order was not followed and such. So to that extent, I think including, what counsel was mentioning about the order can say, well, he'll do this, if not, then there'll be a judicial deed. I think that just skips a step, which is that contempt step. So I don't think that case law permits that. But as it relates to,
Well,
I do have,
and I understand your argument, and if that's the case, that's the case. Hopefully you and Mr. Kessler will be able to work it out. And certainly from an efficiency standpoint, if I can anticipate a contempt and somehow eliminate it, or a possible contempt and somehow eliminate it on the front end, as a judge, I'm all for that, but I also have to follow the law. And so I'll allow both of you parties to consider that. And I expect as much as I would like to be finished with it right now, unless you all can work it out, I will probably hear from you on that issue.
Yeah, maybe Your Honor could even entertain a compliance hearing date, but hopefully we won't need it. Maybe we schedule a date to see.
Well, okay, I see what you're saying. If we don't allow language in the order to include a compliance, yeah, that would be a consideration.
Thank you.
Well, it's Mrs. Ferry's opportunity here, so
I'm sorry.
That's all right.
So I think the question I have, because I think this was maybe a suggestion Mr. Kessler brought up, but the question I have is what does the court intend to enter today? Is it just a final order altogether, resolving all of the issues of the case, or is it just the order on enforcement? And the reason I'm asking that is because, I don't know whether or not, sitting here today, I just don't know whether or not my client's gonna want to exercise any other options, available to him. But I think just for clarity of a way forward, to understand what the court intends to enter, whether it's a final order and then just have a compliance hearing, or is it just the order on the enforcement and then a compliance hearing, then the final,
Well, no, and it was noticed this way. Obviously, if I didn't grant the motion to enforce, I think my court reporter would kill me if I wanted to go on and do the divorce. But that's why I had Mr. Kessler do the statutory questions. So, he's going to present me a proposed order. He'll copy you on it. And it will be incorporating the prenuptial agreement and granting the full divorce based on irreconcilable differences. Now, we have that issue as far as the house and the transfer into the trust and that issue. And of course, Mr. Kessler's argued, his argument was to transfer it today, which I'm denying, but he wants that as a backstop. but perhaps I'll consider it. I know, Ms. Ferry, you've already said that you're skipping a contempt step in there, but if I do go more in your direction on it, then I will probably have I'll want language in there with an automatic compliance hearing on it.
Okay, and I guess what would help my thought process in all of this is what exactly, I know Ms. Williams testified that she has started, the process. I think if it was understood what exactly was needed, I know Mr. Kessler, questioned, because he said he wasn't quite sure either what would be needed. I think that would help. I mean, I don't mind talking to Mr. Kessler, but I think that would help with coming up with ideas, so to speak, because I think we're just kind of assuming that she would need a deed.
Well, I think you hit the nail on the head. Hopefully.
Okay, y'all, I just wanted to answer a few questions. As y'all can see, this video is really, really long. So I tried not to go back and play too much of it because y'all can just go back and watch it again. I mean, we've been on here for almost 3.5 hours. It's getting ready to end. It's just going to go completely off, like in a couple of minutes, actually.
Hopefully y'all can discuss that. And
hey, Judge, sorry to interrupt. Mr. Guabadia he disappeared. I don't know if he dropped off, but
I don't know whether that was intentional or unintentional. Perhaps you can reach out. It's much easier in the courtroom. It wouldn't be the first time that somebody left a hearing while I was or announcing my ruling.
I wouldn't be surprised if his phone died. It's probably what it is or something. Because he was, not streaming, but he was attending using his cell phone.
I don't take issue with going forward because we're wrapping things up at this point. Is there any other questions you have?
Yes, the only other thing, because I don't want to be involved in an email war on the proposed order and the contents of it. I do have some concerns that in the proposed findings of facts, counsel may try to get a little creative and include salacious findings of facts that the court did not pronounce. And so I would ask that not happen. Because again, I'm concerned about
Ms. Ferry, I mean, I want to be clear now. If there's salacious facts, I mean, you're entitled to redline it. But when I read a ruling, even if I go back and write my own order, I mean, I reserve the right to add to it or make changes or whatnot. The ruling's a ruling. It's not a word for word instruction on how to write the order. I just try to provide what findings of facts and general issues that I found compelling. But I guess what I'm trying to tell you is that I'm putting you on notice that what the heck?
Yeah, that one went out. Now this one went out. Oh boy. Yeah, that one went out too. And y'all, that was pretty much how it went. As y'all can see, the entire screen went out. That was it. So that was pretty much it. So I pretty much showed y'all the rest of them tonight. I didn't want to keep breaking it down just because we had Porsha's testimony, then we had Simon's attorney. But what I was thinking, I don't know if you guys got any questions, if you want to come up, I got 30 more minutes. I'll put the link here if y'all want to come up. I'm going to put the link here if anybody want to come up and ask some questions, because I see there were some in the chat that I missed. I was actually trying not to hit it because it kept taking me out of the stream. So if y'all want to come up, y'all got some questions, go ahead and hit the link. If not, I'm going to come back on here tomorrow and we can kind of talk about, everything that y'all saw. But yeah, if y'all want to come up, I dropped the link. Go ahead and hit it. Otherwise, I'm going to end. We've been on here. This is the longest stream I've ever did, I believe. Well, Porsha get 40,000 a month. Well, here's the deal, y'all. Porsha only gets it if he pay, which seems to, that can be the problem because Simon is not in the United States. There is nothing that Nigeria will do because that's a different country. The United States and Nigeria. So if Simon didn't pay, he just didn't pay or he just won't pay. But I don't know. Maybe he will pay. Who knows? I mean, would you pay if you were deported? I mean, I don't know. We'll just have to see. But let me see if I can answer some more questions. Yeah, the Wi-Fi just went out and that was it. And then at that point, I think the judge was trying to get them back. But I would assume that, at some point, maybe he set something else up, but I just left. So let me see what else y'all saying in the chat. I'll try. So the only thing, in watching this entire thing, I really feel like it didn't matter what Simon's attorney did. I feel like, and the judge said that he wasn't convinced. He wasn't moved. He felt like, he was going to kind of keep everything the same. Now, I felt like maybe they could have provided like some income documents. I don't know why Simon didn't provide it, but he also said he didn't have access to certain things. So maybe that's why he didn't provide it. Who knows? Somebody said, I don't want to hear anyone until he appeals. So what else y'all saying in the chat? Let's see. Oh, somebody said, okay. You said, I see why you were so snippy after the hearing. Yes, that was a lot. That I did and the thing about it, when I went down there, I did not know it was going to take that long. I was like, really? Like, what's happening here? Like, it was so unorganized, and it just seemed like, okay, what are they doing now? Like y'all said in the chat, nobody had any proof of anything. They were just talking. Now, I see the comment in the chat about the mediator, and that's what Simon's attorney said, that the prenup also said that they were supposed to have a mediator, and that didn't happen. And that's like some of the things that I was saying. It seemed like if the judge was going to enforce the prenup, then the judge should have enforced the entire prenup. I just feel like because Simon was deported, that the judge just really was like, okay, well, whatever. That's just what I felt. He just didn't seem, to really care. And even, and let's just be honest, Simon did sign the prenuptial agreement. He did agree to it. But with him agreeing to it, even with the judge enforcing it, the judge should have enforced the whole thing, which the judge didn't do. So he enforced the part that was favorable to Porsha, but then he said, oh, well, I'm not going to make her not film in the house. Well, how do you enforce the prenup, but then say she can film in the house when the prenup says that she cannot film in the home? She can't do any of that unless Simon agrees to it. Now, if she were to refinance the house, then obviously, it would be her house in her name, then she can do whatever. But the fact that the judge was like, well, I'm not going to enforce that. I'm just like, are you enforcing the prenup, judge, or not? So that was, a part that just pretty much didn't make sense to me. And also, if y'all paid attention to the part when asked about, her mortgage, she didn't know anything. Like, that's crazy. I'm actually going through the process. I don't know the interest rate, because if you're not locked in, you don't really know what the interest rate is. You just know what the current interest rate is. But for you to not know your bank, for you not to know how much money they're going to give you, girl, that don't even make sense. So it just seemed like, she wasn't telling the truth. And in all honesty, as crazy as it sounds, y'all, Simon did agree to this. Like, he agreed to it. So, I mean, it is what it is. So he did agree to it. Why would he agree to something like this? And I know somebody put in the chat, he wanted a woman, a pretty woman that he can hold, have on his shoulders, I guess, because why would he agree to something like that? And thank you for the super chat. Is it 𝐸_Boogie? I done took my glasses off, but thank you so much for the super chat. But you know, people were saying that, you know, he just wanted something pretty on his arms, I guess, because I don't know why he would do that, but he did it and the judge enforced it. And that's it. That's it. That's all, y'all. I'm about to go to sleep. So we'll come back on here tomorrow since y'all don't want to come up. I know it's kind of late. I'm thinking we'll kind of like have like a little conversation tomorrow, being that y'all have saw all of the videos and it's like y'all was there because I was there, irritated and all. So the only thing that you guys didn't see is the part about Porsha, because she did testify, obviously, you know, to her income, but stated that, you know, she couldn't have it released because she didn't want her, you know, her cast members to know, you know, what she was getting paid. But I can tell y'all it is nothing and not enough for that house. Okay, so I'm going to end this shortly. I thank y'all so much for the super chats. Thank y'all so much for hitting the like button, and I will see y'all